Good morning, everybody.
Good morning.
Get settled in. We'll get the meeting started this morning.
Looked like you were having a good time. Guess not.
Excuse me, we're starting.
We need quiet, please. All right, we'll call the meeting to order, and we will establish a quorum.
Mr. Weathers?
Here?
Ms. Kirkner?
Here.
Mr. Lester?
Here.
Mr. Hoff?
Here.
Mr. Kane?
Here.
Mr. Smith?
Here.
Mr. Klosik? Commissioner Wance?
Here.
Secretary Eisenberg?
Here.
Mr. Chair, please let the record reflect that 7 members are present, and we do have a quorum.
Very good. Let's please stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, item 4 is review and approval of the agenda. Are there any other changes to the agenda?
Just one minor revision with the Mount Airy annexation number from 76 to 45 full property.
Say that again.
I'm sorry, item number 8, Mount Airy annexation, it was misnumbered, so it's not annexation 76, it is annexation 45. That is the correction.
Okay, thank you. No other changes?
No.
Then the chair would be happy to entertain a motion that we approve the agenda with that edit.
So moved.
Is there a second?
Second.
All right, all in favor? It sounds unanimous. The agenda is approved. We have minutes from August 3rd, August 16th, and August 31st. Does anyone have any suggested edits for those? Not be happy to entertain a motion for approval?
I make a motion, we accept the minutes. Second.
All right, any discussion? All in favor?
Aye.
All right, the minutes from August 3rd, 16th, and 31st are approved. We'll move on to item 6, commission member reports. I have nothing to report. Commissioner?
Morning.
Good morning.
Good to be with you all again. What happened to summer? Anybody? Jeez, it went like, like
Just
that.
saying that, yeah.
Just a couple things. As you know, we're still deep into the ag rezoning adventure. And public hearing,
Public hearing is this Thursday, 9 a.m. in person in the county office building, room 311, and in the evening at 7 p.m., and that's virtual, and everything is posted on our website for signing up, and the commissioner's website as well.
see what I did there? I would have stumbled through that. I just went in, as you know. The other important thing from our office is on October the 4th and 5th, we will again be involved in our credit rating adventure that we do each year. This year is a little bit different. Instead of us going to New York, the credit rating agencies are actually coming to Carroll. So we are going to be making sure that they see what's good about Carroll and taking them to a lot of the businesses and putting them in the best area for spending the night that we can and dining them as we can. As you know, we are AAA, which is incredibly important for everything we do in the county. And we were fortunate enough to get that upgrade about 4 years ago, and we've been maintaining that ever since. So 2 days of pretty intense activity with not only our budget folks, but our economic development folks, and it'll be all hands. So that's, again, the first week of October. And we look forward to maintaining, again, our AAA rating. Other than that, I always say thank you all for serving. You guys are doing an awesome job. And as I always say, it never gets old, one of the most important boards that we have. So thank you all. Appreciate it.
Thank you, Commissioner. Any other members have anything they'd like to add or say? All right. Then we'll move on to item 7, which is the administrative report. Madam Secretary.
All right. Good morning, everyone.
Morning.
We have a very long meeting this morning, as you all are aware. And Commissioner Wance, thank you so much for mentioning the public hearing this Thursday. Again, that's at 9 a.m. in person in room 311 and virtually at 7 p.m. in the evening. And there's also a sign-up button on our website as well as the commissioner's website to sign up to speak at the public hearing. It's critical that those wishing to give testimony at the public hearing in the evening use that tool so we know who's on the line to be able to call them in an orderly fashion. And with that, I believe Laura Matthias has 2 extensions.
Good morning.
Good morning.
Yes, so the Bureau of Development Review, Department of Land and Resource Management, we have 2 extensions since our last meeting. The first is Living Waters Garden Center. This is S13007. It is the 7th extension of this site plan, and it's in Commissioner District 3. The second one is Hudson Forest Estates 4, P12006. This is the 5th extension for this. It is a 17-lot subdivision in Commissioner District 4. And that's it.
Thank you.
Thank you.
Next, Abigail Rogers will update you on recent Board of Zoning Appeal cases. Abigail?
Good morning.
Good morning.
So, 2 BZA cases were heard in August. 6404, which was Mulligan Recovery Centers, and that was for the expansion of an existing substance abuse recovery center from 8 beds to 10 beds, with some variances. And that property is located at 829 Franklin Avenue, Westminster, in the R10 zone, which is in Commissioner District 3. Planning Department found the use consistent, and the hearing will be continued on October the 5th. 6409, which is for Wedekind Farm, was for a country inn and events facility at 1733 Wedekind Farm Drive, Westminster, in the agricultural zone, which is Commissioner District 2. We also found this consistent. The BZA approved the use. And then on September 27th, we have 2 cases. 6414, Stairs Valley High Farms, is for a farm alcohol producer and banquet facility with variances. The property is located at 1742 Hughes Shop Road, Westminster, in the agricultural zone, Commissioner District 3. We found this use consistent. 6413, Brown and Brown Companies LLC, is for an outdoor equipment storage yard and vehicle rental at 2007 Liberty Road, Sykesville. The property is in the C2 zone, Commissioner District 5. The Planning Department found the use consistent.
Thank you.
Thank you, Abigail. And that is all I have this morning for my administrative report.
All right, thank you very much. We'll move on to item 8, which is the Mount Airy annexation, number 45.
Okay.
Good morning.
Good morning.
Okay. Good morning, everybody. I'm going to apologize for my voice. I wish the Ravens had the same enthusiasm I had for them on Sunday. So,
Just yelled a little louder in the fourth quarter.
louder, maybe they would have heard, right?
Actually, I heard you yelling from my seats,
Well, at least you heard it, right?
but
I mean, mine were way up there. but-
apparently it didn't help, so whatever.
Not a fun game to be at. Anyway, so starting out, we are here for the Mount Airy Annexation 45 of the full property. You'll remember this was introduced to you all at your virtual August 31st meeting. With us today is Clark Schaefer representing the property owner, Ron Thompson with the property owner, and then we also have John Breeding with the town of Mount Airy.
And we have Doug Fool, who is Emmett Fool's son and a representative of the Fool family.
Good morning, welcome.
And him as well.
I know you didn't know. You just brought him up here.
So submitted with the annexation petition was the plat. This annexation area is approximately 8.3 acres. It is owned by Buffalo Road Investments LLC, and they are also the petitioners of this annexation. Parcel layout, here we have the annexation in the blue outline, the corporate limits adjoining the property with the red border, the Frederick County, Carroll County border in the highlighted yellow. You'll see that the corporate limits are adjacent, so this would not create an enclave. Here is the orthos of the property. You can see there's one improved dwelling on the western side. To the north, we have single-family residential. To the east, we have ballparks, which is part of their Summit Ridge Parks. And then to the south and to the west is agriculture. And then just want to mention that access to the property is on Shiloh Road. Buffalo Road, sorry. Wrong annexation. There was also a site plan submitted with this annexation. The developer is planning on subdividing the property into 9 residential lots. Here we have the zoning. Under the county is currently zoned R40,000, the entire 8.3 acres. The petitioner has requested to be put in the R2 residential zone. Since the R2 residential zone is 50% more dense than the county's R40,000 zone, there is a zoning waiver required, and that has been requested by the town. Designated land use, taken from the 2013 Mount Airy Comprehensive Plan. The property has a low-density residential designated land use, and the requested zoning is consistent with that land use. Water and sewer, we are in long-range service categories for both water and sewer. And then agency comments. I know there was a couple of things to follow up with. The Department of Public Works is recommending the town of Mount Airy assume maintenance responsibility on the frontage of Buffalo Road. And is my understanding from talking with John Breeding with the town that that has been worked out with the Department of Public Works. Planning staff is recommending the town go through a water and sewer amendment to place the property in the priority service categories. And it is also my understanding that the town is already underway with a fall amendment coming up in a couple months. So next steps, we are presenting this to the county commissioners this coming Thursday. So we are here before you for a recommendation on the zoning waiver. Are there any questions?
I don't think so. Mr. Schaefer?
Thank you. Good morning. Clark Schaefer, 73 East Main Street, here on behalf of the applicant, Buffalo Road Investments, which is really Emmett Full and family. The only thing I'd like to say is we obviously agree with the staff report. We received a unanimous, I believe it was, recommendation from the Mount Airy Planning Commission a week or so ago when Hannah came down and presented this matter. And the other point I'd like to make is that the actual density here, as you can see from that plan, is that this is proposed to be developed under Mount Airy's cluster provisions, which essentially will allow the lots to be clustered, and the actual density will be roughly equivalent to the R40 designation that the county has. So we're not trying to stuff a lot of stuff into a small turkey. We're proposing to develop in accordance with the neighborhood, and we would request your recommendation to the commissioners to approve this and waive any sort of a 5-year period. Thank you.
So the action that you need from us is a recommendation to the Board of County Commissioners.
On the zoning waiver, correct.
Okay. Of course, yeah.
So it's currently, so just clarification, it's currently zoned R40,000,
Correct.
which is 1 dwelling unit per acre. The submission plan included 9 residential lots, which is basically 1 unit per acre. So what am I missing here when it's being changed from, you want to change it to 40 to 20?
Sure. It is the town zoning, so because it's being annexed into the corporate limits of Mount Airy, they have to assume the Mount Airy zoning. Under state law, the zoning of R2 is considered generally 50% more intense than our R40 because it's half-acre lots as opposed to 1-acre lots. But how they're developing it in the cluster, the overall subdivision, is gonna be equivalent to a 1-acre subdivision, but we still have to do the zoning waiver for the municipality to meet the state's requirements.
That would allow the development of half-acre lots.
Correct, because it's under the town, now it's moving into the town, so it's gonna be under the town zoning ordinance, correct? But good question. I can see how it would be confusing.
Okay.
Anything else? Any other questions? And you may have said this, and I apologize, the town is in favor of this, I take it?
Correct. John, did you want to speak?
Good morning.
John Breeding, Town of Mount Airy, Director of Planning and Zoning. Yeah, so the Planning Commission gave a favorable recommendation, will be giving a favorable recommendation to the Town Council at an up-and-coming future meeting. So we're in favor of it.
Very good. Always good to know. Thank you. Any other questions, comments? Would you like to make a motion? Oh, yeah. I always forget that. Are there any members of the public that would like to comment on this? Okay, seeing none, hearing none.
Okay. I'll make a motion that we approve the request, the zoning waiver request, and forward it to the Board of County Commissioners for their approval.
I'll second. All right, so we have a motion, we have a second to approve the zoning waiver and forward to the Board of County Commissioners. Is there any further discussion? Can we do just a voice vote on this? All right, all in favor?
Aye.
Is anyone opposed or abstaining? Sounds like it's unanimous. Very good. Thank you. Thank you. Thank you very much.
Thank you very much.
Move on to item 9, which is another annexation. This is in a different town, Hampstead annexation, number 44. And Ms. Weber, you're still,
Still with you.
morning.
Morning.
Good morning.
So I'll get started with the next annexation, Hampstead Annexation 44 of the Michaels property. Did you guys want to introduce yourself?
Certainly. I'm David Bowersox, 24 North Court Street, Westminster, Maryland, here on behalf of the Michaels family. And with me is Steve Smith from Gaylord Brooks, who is a contract purchaser with an interest in the property that's the subject of the annexation.
Thank you, and good morning.
So jumping in, here is the annexation plat that was submitted to the county. The annexation area is approximately 28 acres. I will note that the property extends across Maryland 30, but only the area on the east side of Route 30 is going to be annexed. Orienting ourselves, we are just north of Shiloh Road and west of Panther Drive. We have the old North Carroll High School to the north, and then the elementary school to the south. Parcel layout and overview, the corporate limits of Hampstead, you can see we are on the western side. It's kind of hard to see, but the growth area boundary in the black and gold indicates that we are inside the town's growth area boundary. Here is the ortho. The area is partially improved with one small dwelling on the western side. You can also see there's a pond on the property. Access to the property is from Shiloh Road. Moving on to zoning, the entire parcel is zoned R20,000 with the county. The petitioners have requested to be zoned R10,000 with the town of Hampstead. Since the R10,000 is 50% more dense than the R20,000 zoning, there is a zoning waiver required, and that was requested by the town of Hampstead. And the potential developer of the annexation area is predicting between 40 and 45 lots. The designated land use was taken from the 2010 Hampstead Community Comprehensive Plan that was amended in 2017. You can see the land use designations are R10,000 in the orange, and then a small portion of the property has a designation of R20,000. So most of the property is consistent with the requested requested zoning. Water and sewer for the Water designations, we are in the long-range service categories as well as partially in the existing. And then in the sewer categories, we are in the future designation and it's partially in the existing as well. Agency comments. We did receive a advisory comment from the Bureau of Utilities. The receiving pump station to service this property is nearing capacity. The Bureau of Utilities may not be able to issue approval of future final site development until scheduled pump station improvements have been completed. Planning staff also has a recommendation that the town go through a water and sewer amendment to place the property in the priority service categories after the improvements to the pump station are made. Overall, planning staff is recommending approval of the zoning waiver. Next steps, we are here for a recommendation on the zoning waiver to the county commissioners, and we are also presenting this annexation to the county commissioners on Thursday. So that concludes my presentation. If
Thank
you guys have any questions.
Mr. Bowersox?
Thank you. I guess first I will open it to Jim Rourke, who's here from Hampstead, to see if he has any comments he'd like to make.
That would be great.
Jim?
Thank you. Good morning.
Good morning.
Jim Rourke. I'm Assistant Zoning Administrator for the town of Hampstead. The one thing you may have noticed on this annexation is how they are almost creating an enclave of the farmhouse in the center and the houses down on Shiloh. We reached out as a town to each one of those individuals, each property owner, to see if they would be interested in coming in, annexing into the town. We got responses from some. Some were very inquisitive, but we have not heard back. Some of them were no, and some were very adamantly no. We're not coming into town. But we did try, and I figured that would be one of the questions you guys may have. If you have anything else.
Maybe I'm not seeing the forest for the trees. What's motivating this annexation? Why are we doing it?
Well, right now, the property is not served with water and sewer. This is on the, I call it the inside of the bypass. It's basically the family's property on the inside of the bypass. Mr. and Mrs. Michael have both passed away. The property, 1/2 interest, is owned by Mrs. Michael's Trust, LLC, and Mr. Michael's Estate, LLC. So the family's in a position of needing to dispose of this property. It's on the inside, again, of the bypass. The Michael's farm was once a much larger tract of land. Most recently, 10, 15 years ago, the state took right-of-way area in fee simple right out of the middle of the Michael's farm and has isolated this piece of property away from the rest of its acreage. On the outside of the bypass, the Michaels have also conveyed for public use the site of the existing pump station. North of the property, the Michael family years ago conveyed the site of the North Carroll High School. So that the property is now, we're looking at what appears to be the highest and best use of the property, and that's reflective of the town's comprehensive plan, incorporating it in the growth area with a land use designation that corresponds exactly with the R10,000 zoning we're seeking.
And the issue seems to be long-term, as it is in many instances, water and septic.
Yes, there's already been discussions started with both Hampstead and the county. There is I would mention briefly, a long-going discussion with the county about covenants that were provided at the time of the North Carroll sewer lines that were created about future service to the Michael property when the Michael property is developed. But that's in the background. Also, the family know it's not an immediate situation. But we've got to do something to dispose of the asset.
Okay. Are there any questions?
I noticed on the report that in terms of schools, the comment was made there will be no additional impact on school population. So adding approximately 100 residences has no impact on the school?
There won't be 100 residences. It's projected to be 40 to 45 maybe,
And that has no impact on the current?
not on the annexation. At the appropriate time, when we know what the layout of the development is going to be, Hampstead has adequate public facilities ordinances that will need to be complied with before we get any approval to develop. And they include, under the county's concurrency scheme, adequacy of schools, as well as water, sewer, road systems. So we're here today, again, like the case before you. We're merely asking for the 5-year consent or waiver, whatever we're calling it, under the state code, to change the zoning from the current R20 to R10. And in doing the request to R10, we're asking to be able to bring the property into Hampstead with the zoning that Hampstead has already designated as appropriate for this property when it comes into town.
I can also add to your concerns. As part of the county's process, we send out for agency comments, and one of the agencies we sent to was the Board of Ed. And I spoke with Mr. Will Kane regarding the annexation, and he provided no comments. So I take that as there's not really any concerns as of right now.
All right. So as we sit here today, there's no opposition, at least so far this morning.
Well, let's hope not.
All right. Let me pause and ask if there are any members of the public that would like to speak to this issue. Okay, it appears none. Are there any other questions?
If you will allow?
I will.
Mr. Chairman, thank you. I notice on the notes that there's an additional access to this property off of Emory. Is that correct? Or
I
no?
think that's the next case coming
is?
up
I'm
on the
sorry.
agenda.
I got the wrong one.
That's quite all right.
This is got it. Okay, sorry.
No problem.
Next one. Sorry. Skipping ahead.
That would be quite an access strip to the property, but
Yeah.
That was actually, Mr. Bowersox, a test, and you passed.
Congratulations.
Well done.
Yeah.
might as well go home.
All right, any other questions before we
Sorry.
see if there's a motion?
I'll make a motion that we recommend annexation of this property in R 10,000.
Right, 20,000 to 10,000.
Zoning waiver.
With zoning waiver, yes. From R 20,000 to R 10,000 to the Board of County Commissioners.
We have a motion. Is there a second?
A second.
Okay, so we have a motion, a second, to agree to the zoning waiver and forward to the Board of County Commissioners. All in favor?
Aye.
Anyone opposed?
I'll make sure I got the right one on Thursday.
Okay.
Thank you.
Thank you. Thank you very much, Jim.
Thank you.
Next on our agenda is item 10, which is the Hindman property. It's case M21-0046.
Good morning, Planning Commission.
Good morning. Welcome.
I'm Kirsten Nagel with the Development Review Office, Bureau of Development Review. We are here for the project M210046, the Henman property. I'm going to allow everybody who's up here to introduce themselves as well, if we could.
Good morning, Commissioners. My name is Mustafa Zadi. I'm the engineer for this project.
Good morning.
Hi, I'm Ruth Heinman. I'm the owner of the property.
Good morning.
My name is Tom Bonin. I'm one of the future purchasers of the subdivision property. And with us also is Patrick O'Connell. He is the second, buying the second subdivision property.
Okay, very good. Good morning.
Thank you very much. Thank you very much for being here. Okay, so we have a PowerPoint for this. Let me load that up. Okay. So this project is a subdivision project. This is a minor subdivision, M210046. We're here before you today, instead of just for the subdivision, we're here regarding a modification request that was submitted in conjunction with the subdivision regarding the use in common driveway. The subdivision is proposing that additional lots be added to an existing single-user driveway, which will change it into a use in common driveway. So there's certain requirements that are applicable to it then. And we're here for a modification request that was submitted by the owner-developer regarding that. So we are located at this site here. We're off of Emery Road North, or North Emery Road, just about a mile northwest of the Carroll-Baltimore County border and Maryland 91 Emery Road, where that meets the border. As you can see on this image here, this is the zoning layer turned on, so everything basically to the north of North Emery Road is ag zoned, everything to the south is essentially conservation zone. You can also see that a lot of it's farmland, and there are quite a few houses. You can see some smaller subdivisions in the area as well. Some of the larger farms are in agricultural preservation easements, but not this one. This is about a 20-acre parcel. There currently is only one house on it. Again, it is zoned agricultural, and we're in an area where they utilize private well and septic systems. You can see on this image here that there is an existing house essentially at the center of the property. That's actually the high point of the property too, so it slopes downward in all directions from there, including the driveway, which it's a little bit hard to see in these drawings, but it wraps around the front of the house, follows the property line, and then connects with North Emery Road here. Okay. There's a stream you can see here along the eastern property border. There's also an area of wetlands and this area here, right near where the driveway meets the public road. So, again, this is a subdivision that's being processed. It's a minor subdivision being processed. They're proposing to divide 2 lots off of the parent parcel, if you would. We're here for today, not for the subdivision itself, but we're here for the driveway, because again, these 2 houses are proposed to be accessed by using this driveway, which will become, therefore, a use in common driveway. The existing driveway is 10 feet wide, and the owner-developer has submitted a request in accordance with our code to see if that driveway can be maintained at 10 feet wide as opposed to being adjusted and widened to 12 feet wide as typically be required by code for a use in common driveway. This is in accordance with our code. Again, it's the modifications section of use in common driveways. And I'm not going to read the whole thing. It's a very long piece of code here. I'll read a little bit of it. So it's chapter 155025 modifications, where the Planning Commission finds that because of unusual circumstances, shape, topography, or other physical features or conditions of the proposed subdivisions, or because of the nature of adjacent developments, extraordinary hardship may result from the strict compliance with the use in common driveway design requirements of this code and the development manual. There may be granted a modification when requested by the subdivider and developer. So that was what was submitted to us with this submittal of the subdivision request itself. That's the wrong one, so bear with me. I'd like to read the actual request itself in the words as it was submitted. Again, the driveway is existing, it's 10 feet wide, it's paved. They have submitted a request that was circulated through our review agencies for the following. As per the Development Review Manual, a 12-foot wide paved driveway is required for use in common driveways for minor subdivisions. The proposed subdivision has an existing 10-foot wide paved driveway, which is in great condition and goes through wetlands buffer at the entrance near Emery Road. Any widening of the proposed use in common driveway will further impact the wetlands buffer. The existing driveway is over 25 years old and has been resurfaced in the past 10 years. The 2-foot widening width is very narrow and will create continuous maintenance problems due to the driveway's different sub-base condition of a stable old driveway and the new unstable 2-foot widening by breaking off in separation from the original driveway. So they requested that for those reasons, they be allowed to keep the driveway at 10 feet wide as it exists instead of increasing it to 12 feet wide as would be required by code. And I will note too that this request is the only deviation from the use in common standards that is being requested. If you look at the drawing, you'll see that there is a pullover at about the midpoint as required by the code otherwise, as well as a turnaround at the end as required by the code. The driveway is also paved, it's existing paved, which would have been required by code, and it's going to be a named driveway since they have 3 or more users now. So it's meeting all the other requirements. This is the only modification request. On the drawing too, since we're looking at it here, you can see the area of wetlands referenced in the letter here. It's my understanding that modifications or disturbance in the wetland area has to go through the MDE as well, which I believe there was a request submitted for, but I'm not sure that that developer has heard back from the MDE regarding that request. I will also note, and this is not shown on the drawing, that there is an easement on this driveway. This will be shown on the next drawing. It was overlooked by the surveyor when this was first submitted. There's an easement that goes from the public road to this point here. It follows this single property line, and it allows for access for this farm property over this existing property here. So that's an existing easement that was established actually when the parent parcel deeded a portion of the property for farm use to a neighbor. So that's an existing easement they would utilize the driveway, but this modification is for the pavement of the driveway and not for eliminating or changing any users. So that would not change. I will also note that the request that I read was sent to a few of our review agencies, that if we were to have read that entire modification section of the code, you'll see that it recommends that the request be sent to certain agencies: planning, office, engineering review, fire protection, and resource management reviewed this. None of those agencies had comments. The only comment that was made was from engineering review that stated that the 2 foot of widening, adding 2 foot of pavement widening to the existing driveway would likely cause maintenance issues for the property owners. Compaction is difficult to obtain on widths less than 4 feet, which could cause cracks and failures in the pavement, was what the engineering reviewer said when that was circulated. But besides that, there were no other comments. We have had comments from the public, however. The neighbor to the north called and had questions about the easement there and about how this would impact the easement and the issues with the driveway width currently regarding driving farm tractors and so on over the driveway, and the driveway being not quite wide enough for that kind of equipment. So those were the comments we've received for this project here, and that is it. I'd be happy to answer any questions. I'm sure the owner, developer, and their engineer would be happy to answer any questions for this as well. Again, the only action we're seeking today is a determination regarding the modification request regarding keeping the width at 10 feet as opposed to widening to 12 feet.
Thank you. Would you all like to add anything?
Good morning. Yes, we have already asked MD for a request for impacting the buffers. And based on recommendations from our environmental consultants, John Canals, he recommended to do the widening for the first probably 100, 150 feet or more to the west of the driveway to stay away from the wetlands itself, and then switch over and go to the right when we are away from the wetlands. However, if we decide to widen it to 12 foot, we cannot go to the left for grading, and we have to stay on the right side or the east side of the driveway, which is closer to the wetlands. Those wetland is like that finger, yeah, right there. Those are the wetlands. And so far, MD hasn't done anything, waiting for today's hearing to see what would be the decision. And also, my concern is that the driveway, it drops off, and they just provided me this picture that it shows like about 9-10 inches of drop if you want to have a flat driveway. So it means we have to do more disturbance, and so the disturbed area would be more. And in addition to that, Carroll County has guidelines for stormwater management, which is different from the other neighboring or municipalities or MDE, and they require to provide a stormwater management for the entire site, and they give you the chance of excluding some areas from stormwater management. Like if you have floodplains, you can exclude that, or the areas that are not draining into the disturbed area or LOD, we can exclude that, and whatever remains, then you have to provide stormwater management. We originally designed the stormwater management for the disturbed area, which is about 2 and some acres, but now, based on the Carroll County requirement, it's gone up to 12 acres. We have to provide stormwater management for 12 acres. And if you, I don't know if you can see this, this area, which remains in the remaining portion and is next to the driveway, if we don't do any widening here, that's not going to be a part of LOD or disturbed area, so we are excluded for providing stormwater management for almost 2.5 acres. And that would be a very hard hit on the property owners to provide the stormwater management. The site is pretty rocky, and we're going to be doing a lot of borings to make sure we find a good place for dry wells and either landscape infiltration or bioretentions. So that's why we're here today, to see if we can get a variance and not to increase the driveway width, and with the consideration that based on one of the reviewing agencies, they say either cut 2 feet off the driveway and add 4 feet, because 2 feet widening will not be stable, or add 4 feet to the existing driveway instead of cutting 2 feet off, so it makes it 14 feet. So basically, it means more impervious area, more disturbed area, and more stormwater management. So here, we respectfully request your approval to stay, keep the driveway at 10 feet, and I'm not a farmer, but my grandfather was a farmer, and when you have farming equipment, it's all muddy and goes through dirt and everything, and driving a part of the farm equipment on the grass, I don't think is going to be that important to make that driveway 12 foot wide to keep the neighbor in the north happy.
Anything
That's
else
all I have.
you'd like to add?
I don't understand why the driveway would need to be widened to allow access for the farm equipment when the farm equipment's been using the same driveway for 28 years that I've been there.
The actual right-of-way was 50 years ago, before she bought the property, and it was just dirt. You purchased the property about 30 years ago, and it was gravel for several years.
Right.
Till then, she put a 10-foot driveway on, has since had it resurfaced, and nowhere during that time had it ever come up that he needed wider, would like to see it wider at all.
It's never been a problem.
I don't know where right-of-way also means we have to give it into certain condition and maintain it, and the cost. And obviously, our core thing here is the MD wouldn't give us a ruling, like you say, because they understood we were putting the petition here, says, well, we're not gonna get involved, because they may not need to get involved. So that's our concerns. And then, like I said, the further up you go, there's drop-offs as much as 8 feet if you go 2 feet, 8 inches rather. If you go 2 feet wider, it gets even more the further out you go. If we have to go additional 4 feet. And honestly, for the last year and a half, he used to farm the fields there for grass. He hasn't been mowing those since we disturbed it to do the perk test, because he doesn't want to damage his equipment. And prior to that, the last time he maybe saw a piece of equipment,
3-4 years.
because he actually has
4 or 5
access off of Emory Road North, a little further up. And if you saw in the one picture, the barns and everything are there in the middle, so he can reach them from the other access points too. But again, we're not doing anything anyway, we're not disputing it, he has the right of way. He's free to keep using it.
Right.
10 feet works for us, that's why we're here as the future owners. We store our campers there, have no problem with 10-foot driveway, it works well for us. It's just, thank you for your time, I appreciate it.
Do you all have any questions?
My only question is, maybe I missed it somewhere along the line, but could it be subdivided more at some point?
Oh, I'm sorry, I meant to mention that right off the top. These are the last 2 lots that can be taken. So once this subdivision is complete, there's no further division of the 2 new lots or the existing parcel. This is gonna be it.
It actually could be subdivided 3 right now, but she's elected not to do that. She doesn't want that many
No,
homes back in that area.
It only has the 2 rights, 2 lot
I
rights.
thought it was 3.
There's,
Either way,
Okay, so
this is
change
it.
All right.
'cause it's 3
We have
three
no
houses
desire.
total. Yeah.
So we don't have an issue with the number of users exceeding.
So my only question then would be for fire and equipment.
And again,
Oh,
I always look down there, for that guy down there for his answer
He's
on
the
that.
expert on that.
That's one of the reasons why it was changed to 12.
Yeah.
we requested, as she said in her comments, from them, and they had no comment.
Yeah, that's why.
Or was it no comment, or are they okay?
From which agency?
Fire? and
Fire protection had no comments.
But we take the no comment to mean okay?
Yes.
If I may,
Sure, step to the microphone if you don't mind, please.
it was stated a little bit earlier, we both store our campers there currently. I've got a 29-foot tag-along. Tom has a 34-foot fifth wheel, and we're able to get in and access the driveway from Emory Road North without any issue.
Excuse me, can you give your name for the record, just so we have it for the minutes, please?
Michael O'Connell.
Thank you.
Thank you. Are there any members of the public that would like to comment on this? Mr. Schaefer?
Good morning again, Clark Schaefer, 73 East Main Street. I'm here on behalf of Dick Weaver, who is here as a farmer and owner, not as a county commissioner. First, you know, it all sounds great, doesn't it, and easy. But the bottom line is that this property is situated such that it apparently has some difficulties. Not it can't meet the requirements. It's just that it would be difficult. And you've heard the horror stories, and believe me, I do this kind of work for a living. I've heard the horror stories. We've got to comply with stormwater management. Do you understand how onerous that is? Yeah, costs money, doesn't it? But you've got to. This property is situated such that apparently it's somewhat difficult and more expensive to put in the required county driveway. Now, from the Weaver standpoint, here's a question. Question number one is, why was, you just heard, 28 years. We knew there was an easement there. We knew, this guy's fine. Don't worry about him. He's going to be fine. Well, why didn't you show the easement on your submittals? Which, by the way, it's required in your code that all easements or rights-of-way of record or on or across a parcel being subdivided shall be shown on the preliminary plan, the final plan, and the final subdivision plat. Well, it was just pointed out to you this morning that, yes, there is an easement, but no, it's not on the plan because it wasn't shown on the plan. It should have been shown on the plan. It's a 20-foot easement recorded in the land records on behalf of the Weaver family to get access to a farm parcel, which, by the way, the access is not restricted to agricultural uses. It's just a 20-foot right-of-way. So that being said, the Weavers have experienced access issues. And before we came in here, Dick Weaver was showing me a video of a camper, a large camper, which was maybe one of the ones just referred to, that had some difficulty getting back there on the 10 feet, had to go across the grass as it got back there. So your code says extraordinary hardship. You've heard a lot of allegations about what 2 feet of asphalt, how onerous that is. It doesn't, I submit to you that it may not be that onerous. The bottom line is, it's gonna cost more to put it in there. And it's true, you could have left they could have left this gravel. Mr. Weaver would be fine with gravel access. But they chose, apparently at some point, to put in a 10-foot wide driveway. And now they want to subdivide, and when you subdivide, you need to meet the requirements. Luckily for them, they have fee simple road access. I don't know if that was carved out or not. But the 12-foot driveway should be required here. And it's not enough to just conjure up these problems that may occur because of qualities that exist on their property. You know, a wet area. Well, every property comes with its own unique set of challenges and circumstances, and anybody that's ever done development knows that they restrict and make it more expensive or less expensive your development. We object and oppose any lessening of the standards for the width of the driveway. Thank you.
Mr. Shaver, I just have one question to make sure I understand. I'm getting a little bit lost on the failure to show an easement. How does that relate to the width of the driveway?
May I answer that, please?
Let me ask Mr. Schaefer first, and then certainly.
I'm sorry.
Well, it doesn't. It relates to the fact that the drawing was submitted without an acknowledgement of a property right of an adjoining property owner.
Does it have anything directly to do with what?
No, it doesn't. It's just that the staff wouldn't have known about that unless Mr. Weaver noticed it and pointed it out, and then came to me, and I looked it up in the land records. For your information, maybe you don't know this or not, but the engineer might need to not jot this down. It's 574 at 253 is the first deed, 8322 at 287. These are deeds that are on record that are required to be acknowledged on, for obvious reasons. And the final plat, and there's lots of plats out there, and I don't know how often you read them, I read them a lot, but when use in common driveways, it'll have this use in common driveway users are lots 1, 3, 8, and 12, and 5474, you know, the Weaver parcel, so that everybody knows and recognizes other people's rights to use the driveway.
If I may, the plan didn't show it when the plan was submitted. However, the legal documents and the title certificate and the deed history did show that easement. So I can't say that it was an oversight of the surveyor compared to a miscommunication with the attorney who was doing that research, but that easement was recognized when the plan was submitted, or with the plan submittal.
Sure. Let me hear from the engineer also. Thank you.
Yes, thank you. The reason that it wasn't shown, it was not intentional. When I signed a plan that everything is shown according to the records, I mean it. What happened, this property was surveyed when Mrs. Heineman built the house many, many years ago by Fisher Collins. And when they decided to do subdivision, they hired John Melmore, who's another surveyor, and he tried, and he couldn't close the property. They had some issues with some boundaries on the basically north side of the property and north and probably east side of the property. So they finally decided to go back to Fisher Collins and say, come on, you did the survey, you gotta do due diligence to close close the survey and give us a good survey. And this job was on hold for 5-6 months because they were going back and forth. And I, as an engineer, when I get drawings to work on it, I get AutoCAD drawings. And the AutoCAD drawings that I got emailed to me did not show that 20-foot easement. And under no circumstances we're trying to not show it intentionally. The survey that I got, it didn't show it, and then later on, as soon as Ms. Kirsten told me about it, we just put it right on, and the title
Our
company
title
told us.
company found it. Apparently it was a little convoluted, like it wasn't stated right on front on her current deed. It was buried somewhere else. It didn't stand out initially. But once he brought it to everybody's attention, as Kirsten said, it was submitted. We admitted it first thing today, even though it's not on the drawing. Yeah, there's a little more history to all this since this began. And I'm, I didn't realize lawyers were gonna be here. I'd have our lawyers here. I'd have our contractor that looked at the driveway. Maybe we would've pushed MDE to make a decision, because they said, we're gonna take a back step because we don't even have to. Let's see what the board decides since you're asking for this variance. But
The issue before us today is pretty narrow. So all of those things really are background for us,
Right,
but the real
right.
question for us is.
There's even more background noise that.
Yeah, and I'm not sure we need to know all of that right now.
Right, exactly. So, go ahead.
Okay. Mr. Weaver, I think you wanted to say something to us?
Yeah, Dick Weaver, adjoining property owner. I just want to ask to stick to the code. Every time we get use in common driveways, not with these people, but the second generation, third generation, as a house gets sold, these issues pop up. All I'm asking to be done right, especially through the wetlands, right off the bat, not later. Thank you.
Thank you. So, speaking from myself, I appreciate all of the comments from everyone. It's been very helpful, and understanding the context always helps to fill in the picture. And obviously, we'll have a broader discussion. The statute, I think, matters because it's what gives us the power to either decide or not decide, or to make a accommodation or not make an accommodation. And so, and Mr. Schaefer had mentioned the extraordinary hardship, and that's correct, obviously, but it also has other provisions too. It says where the Planning Commission finds that because of unusual circumstances of shape and topography, or other physical features or conditions of the proposed subdivision, or because of the nature of adjacent developments, extraordinary hardship may result from strict compliance with the UIC design requirements of this section and the development review manual, there may be granted a modification when requested by the subdivider or developer. And then it goes on to say, however, no such modification shall be granted which will have the effect of nullifying the intent and purpose of the master plan, the zoning regulations, this chapter, or any other pertinent rules, regulations, or laws of the county. And then so that's the framework we have to work within. It goes on to say, prior to considering such request, the Planning Commission shall refer the matter for technical agency review, which will include the Office of Public Safety. And I take it all of that's been,
Correct, those were the 4 agencies that are referred to prior.
and no comment.
The only comment we had again was that, and I'll
Wetlands.
note too, that the Office of Planning found the request consistent, I believe. Let me read their language. Everything else was literally just no comment. This one stated, well, engineering review's response was the one that I read previously, where they stated that the widening of just 2 feet would cause maintenance issues, was the only comment that they had. Office of Planning stated the same thing that you just read, that no such modification shall be granted, which will have the effect of nullifying the intent and purpose of the master plan. The above referenced subdivision plan proposes a 20-foot wide pullover, a T turnaround, and currently a 12-foot wide driveway. The requested 10-foot portion of the driveway is approximately 1,050 feet long. Modification request from 12 to 10-foot wide use in common driveway will not have the effect of nullifying the intent or purpose of the 2014 Carroll County Master Plan 2019 amended. So everything else was literally no comment. Theirs was stating that there is no issue, that it is in conformance with the master plan. And then, again, engineering stated that the 2-foot widening would be a maintenance issue.
Thank you. So the way I read this is that if we find that because of either unusual circumstances of shape and topography, or other physical features or conditions of the proposed subdivision, or because of the nature of adjacent developments, extraordinary hardship may result from strict compliance. So, are there unusual circumstances of shape and topography, or other physical features or conditions of the proposed subdivision, in this case, the lane? You've talked about the drop-off, the wetlands, and the fact that widening it 2 feet causes, there's some compaction issues can be dealt with by cutting it back 2 feet and then having 4 feet. And I guess the question is, does that constitute extraordinary hardship or not? The code doesn't really tell us what extraordinary hardship is. And Mr. Schaefer is making the case that this is an issue that comes up lots of times in lots of circumstances. It doesn't mean it's not extraordinary hardship. Doesn't mean it is. So I think that's something but that's the framework that we have to look at this in. And I think in my mind, at least, it boils down to whether this drop-off and the potential impact on the wetlands of widening would constitute an extraordinary hardship. And I think it's a close case, honestly. I mean, we've seen other examples of where it's obviously an extraordinary hardship. This would be less so, but these are hardships. Are they extraordinary? It's expensive.
That was my
And it's gonna cause long-term
And we haven't
problems.
brought up the cost necessarily, but what, again, and like I said, if I'd known, we could have brought lawyers in, I could have had estimates to go, okay, it's gonna be this, but what's extraordinary? It's $1,000 is a lot to somebody, $100,000 is a lot.
That's right.
Where's that line?
Right. And the short answer is there's probably no bright line test. So we have to weigh all of these things in the broader context, and that's why the broader discussion, I think, is useful. So let me stop talking and see how.
I would say my one question is, I would imagine the Weaver property is in ag land preservation currently?
No.
No. So if he has a right-of-way, he could actually add 2 more houses to that, or 3 more houses to get to 6 for a common use driveway. Am I correct in that?
May I comment?
Wait a minute, let me have Kirsten respond first.
So when I was doing the research on this property, our records indicate that, and property lines here are very difficult to see. Here we go. There are multiple parcels that are owned by the Weaver family. This parcel here in particular, not the little one, I'm trying to get my mouse to the right spot. This one right here. This parcel right here used to be part of the property that's currently being subdivided. I might have the paperwork with me, but that property at one point in time was deeded over to the property is currently owned by Mr. Weaver. And that was deeded over as an agricultural parcel, not for residential development. I'm not sure if I have it in here. Oh, I do. Yeah, so it's specified in our records as for farming. The purpose was for farming. If it was processed in a different manner and it wasn't specified for farming, that possibly could have been utilized for subdivision or something of that nature. But from what our records indicate here, and again, that was not something that's not part of this subdivision process, right? So I was just noticed during this review process that our records indicate that that parcel was deeded over for farming, so now.
Transfer lots across ag lines, can't you?
I was gonna say, that's not to say that the other properties in the area don't have residential development, but that's something that would have to be reviewed in detail if and when something were proposed. So I just wanted to note that the property that has the right-of-way currently is restricted to farming based on our records. But again, like Mr. Schaefer just noted, there is a possibility if there's land rights otherwise, they can be moved around.
So there potentially could be.
Potentially, it would have to be reviewed at the time that it was requested.
Sir, did you have something?
Well, and again, I didn't want to make more noise, but Mr. Huff, you brought up the point about the subdivision. We actually had a conversation when we started all this with Mr. Weaver, who at the time wanted to buy a parcel from us, from Ms. Hyman, and she said she wasn't interested. From that day on, that's when the problems began. And the comment during one of these conversations was, look, sell me some land, I'll put everything in ag reserve because we know that's what you want. And I honestly said to him, we don't care what you do with your property, it's your property, you have the right to do. Well, I've already found out I can subdivide up to 14 lots through all this land over here, and I'm just gonna do that. Had you not asked that question, I wouldn't have brought this up, but that was a conversation we had on a Sunday morning on his lot when we discussed and brought all this to his attention. So maybe there is some intent there, Mr. Hall.
So I object to that characterization. I do not object to the fact that if there was a factual conversation, but I object to the characterization of that's when the problems began. The problem began when the property did not have enough apparently characteristics to allow them to meet the county code. Mr. Weaver is a neighboring property owner with a recorded easement over a portion of this property.
Disputing that.
He's entitled to object. If that's a problem, then that is a problem. But there's no credible basis for the fact that this is generated by some kind of anger or ill will. He's trying to get, he has some issues getting into his farm field over that easement, even now. So that's the problem.
All right, so I think, we cut off the discussion now, let us talk about it. I think we have a good picture of the circumstances. Matt, did you have any other questions on that? Michael, did you have any?
I said the only comment I would have is that as a farmer, 10 foot is not enough for anything.
Is 12?
Yeah, well, it's better. I mean, most ag equipment is, well, some of it's up to 15, but most of it's under 12. But
So there's a easement on the adjoining property too? Am I correct? Is that what you said, Kirsten?
The easement that we're referring to here runs from the public road, North Emery Road, and this property line here that goes straight to where it meets this corner, about 530-some feet long. That's the full length of the easement. It literally goes from the public road to the very westernmost corner of the Weaver property.
Okay, and how wide again?
20 feet wide.
20?
Yeah, from the property line.
Okay.
I've got a question, Jim, I guess this goes to you. Is there any reason for us to require this drawing to be updated to show the easement so that it properly reflects the Weaver rights?
I don't believe so. As Chairman Wather said, the issue before you is pretty narrow, and it's laid out in 155-025L, which is a modification. It's not a variance, it's a modification, and I just wanted to make that clear. So your decision has to be made within the guidelines of that subsection. An easement not being shown on a plan doesn't
erode his rights in any way?
Right.
Okay.
And
I just
it
wanna make sure we're not-
doesn't really
we're not screwing up
affect
there.
the
Okay.
decision that's before the commission right now.
All right, thank you.
And I will note also that, again, it was an oversight that it wasn't included in the drawing, but it was included in the documentation, so those will be
Merged.
corrected. And yes, you will have, we will see that drawing updated to show that easement.
We've seen modifications to other properties, and I think we need to be cautious of what we consider hardships, because we've definitely modified others with maybe a similar instance, so,
Meaning granted the modification?
yes.
Right. It's not uncommon to have these requests made. The circumstances in each one is different, and we try to take all of those into account. So it's not a one-size-fits-all, certainly. So I'll lay out sort of where I come down on this, and you can agree with me or you can disagree with me. I tend to come down on the side that I think that the shape and the topography, given the length of the driveway and all of the circumstances here, you know, it's a close call in my mind, but I do believe it meets the extraordinary hardship standard. As I said, it's not a bright line in my mind. Each case is different. It's not just hardship, it's extraordinary hardship. So extraordinary modifies hardship. So it's something more than just it's inconvenient. I think this is more than inconvenient. I think trying to come up with a workable solution to go from 10 feet to 12 feet is going to be not only extraordinarily expensive, which in and of itself, as we see these things, is not, I mean, I don't think that's enough just to say it costs a lot of money to comply. It's in good condition now, according to the pictures. It has the extra space for pullover, it has the turnaround. The number of users is not a problem, but to add 2 feet to this under these circumstances where the drop-offs are, as they've been shown to be, and the continuing maintenance problem, and the disturbance of the environmental areas, I think all are enough for me to at least get it across the line to extraordinary hardship, but just barely. That's me. I'm one. I don't even get to vote. But that's my sense of this.
Yeah, I do not disagree with your assessment. I think, again, it is just on that border of hardship. As I look at the topography, that is, being from a developing background, that is hard to increase something and not have issues with it.
And stormwater management.
Right. Yeah.
Michael, what do you think?
Well, my concern is precedent, and, you know, as we heard in testimony, the code is there for a reason, and we keep on, getting approached for, allowances to the code. So, you know, I have a code, maybe that's harsh, but, you know, the code to me is a standard. It was established for a reason, whether it be for farm equipment or whatever. And then we get proposals, have discussions to have that, you know, variances or changes made because of circumstances. I hear the circumstance of hardship here. But my concern is that we just, you know, precedent keeps on being established, that the code really is not strong, not, you know, it's not something that is sound for basis, decision-making basis from our perspective.
The one thing I mean, this is our discussion, so I think, and it's really healthy, because we're gonna have another one of these in about 5 minutes.
That's what I'm saying, that we have exactly right.
And that won't be the last one. I take your point, and I agree, the code sets standards, and in this case, you know, 12 feet is the standard. And I know Mr. Schaefer was making the argument on behalf of Mr. Weaver, you know, just apply the code, have the code requirements. The code also has modification.
No question.
And that's part of the code.
If then else, yeah.
That's right. And I agree with you very much on the idea of precedent. And that's why I was trying to be clear to say, I don't think saying something is expensive is enough to ever meet the extraordinary hardship standard, because every development is expensive in its own way. We recognize that. We try not to hold things up, but they're always expensive.
Right.
And so I think it takes something more, and from my standpoint, from a precedential standpoint, I think it's got to be more than it costs a lot. And even it costs a lot to maintain it. Here, I think, keeping that in mind, your point in mind, I think there is more. There is something more beyond. As I said, I think just, in my mind, barely enough to make it more. But I am very mindful of the precedential value that you were raising, and I think that's important always. Matt, did you have any more? Or where do you?
No, I don't, if it was just 3 houses is one thing, but then having the other right of way, and it could possibly have 3 more houses on that common in use. Or unless they came to us, they could ask for a waiver of that, because we get those all the time also. I really think it should be 12, because that's what the code is, and it's a long driveway with turns in it for, you know, emergency equipment to get in, so.
Okay.
When was the property blacktopped? I mean, it was dirt and gravel.
96, 97 was the first time we paved it.
Okay. So it was able to be operated with the 10 feet and farm equipment that could go over it at that point in time? Is that correct?
Never had a problem. It was dirt when we moved in, and then gravel for the, you know, the building stuff. and then a couple of good rains washed it out, and then that's when we had it paved.
But my point is, when it was paved, the farm equipment from Mr. Weaver's,
Never a problem.
so he did go,
Absolutely.
it did go?
Yes,
Okay,
yes.
that was my question.
Yes, I'm sorry, no. Yeah.
Okay. I personally am still concerned with that topography. Adding 2 feet across there, what it's going to do. I've seen driveways that do exactly what the planning department said. They do crumble. It's hard to build a base that will keep that straight.
And that leans you in favor of the extraordinary
I-
hardships.
Yeah, pretty much.
Can I ask a quick question?
Sure.
I mean, I've seen a lot of driveways where they've been widened, but maybe they just put stone around the corners and stuff like that. Could it be stoned, the extra part, or does it have to be asphalt, so it's all the same?
The use and common driveway standards require the 12-foot wide paved, so adding 2 feet of gravel on the side would not meet those requirements still.
That's great.
And if I may add, if you just put gravel there because of topography, couple of rains is gonna wash it away. It's not gonna stay there.
What are your thoughts? I have nothing to add to the conversation. I will echo what, as a relatively new member to this commission, it's amazing to me how there's a line in the Pirates of the Caribbean, that there's really no code. They're more like guidelines. There's no rules. And I'm concerned about the erosion too. I mean, why have them? I mean, we have county staff that does a great job of developing them, and then we reduce things all the time. At the same time, I see exactly what you're requesting here. It makes sense that we would do it in this instance. So I have nothing, I've added, and I said I had nothing to add, so I'll shut up.
We'll pause there for a moment, and Stephen will.
Yeah, I mean, I agree with Mr. Kane and Mr. Huff, just especially with precedents, and to me, it becomes a slippery slope. It's like, okay, so yes, the topography, and then that's our interpretation of what difficult topography is. I mean, we all know Carroll County is not a level county in general. So I just think that it creates such a slippery slope, and the basic code is there for a reason, and the code says 12 feet, so, why have it if we're always going to continually change it or make it, easier or more difficult for people, so.
If I was a mediator, I would say, make this 12 feet to where the easement ends, and then 10 feet the rest of the way. But that's so arbitrary. I don't like that either. And so, again, I'm adding, and when I said I didn't have anything to add, when I was sitting here listening to it, I said, well, let's make it 12 feet to the corner, to that bend. And that gives me a level of comfort for the emergency vehicles, for the farm equipment and everything else. But the problem here is the extraordinary problem, if there is one, is at the front of the property there. And so, again, that doesn't give you the relief you're looking for. So, again, if I was looking for a middle ground, that's what I would do as a mediator. But again, we're not trying to mediate anything here. We're trying to come up with a decision that makes sense. So, I don't know.
I still lean towards the county, the planning department, stormwater management. They've all kind of indicated that there is an issue with adding 2 feet there, and they are the experts, so it's not us saying that, this is the problem. Just go ahead and don't do it. It's we're being advised that there is a potential problem to do that.
Yeah, I think that's a good point. And look, to your points, Pete and Stephen, I share your concern about eroding what the code says, but But I think there's a modification provision in the code for a reason.
yeah.
And it's to take these things into account. Now, whether they meet the standard or not, I think really,
That's the issue.
technically, that's the question
That's the
today.
issue.
Is this an extraordinary hardship in your mind? If not, why not? You don't have to say it out loud. If yes, why yes? Again, you don't have to say it out loud, but when you vote, it seems to me that's the,
That's the
when you
question.
distill it down to its essence, that's really
Mhm.
what we have to decide today. Does this meet the extraordinary hardship standard? And every case is different. It's going to be fact-intensive every time. In 5 minutes, it's going to be fact-intensive again. So this is important to you, very important. It's important to us. It's important to us for this case, and it's important to us for the next case. So I appreciate everybody hanging in there while we work through this and make sure we understand the implications here for you, and we do appreciate the implications to you. Either, however this vote comes out, I want you to know I think we've looked at it from every side we can to be as fair as possible and to weigh the competing interests, Mr. Weaver's competing interests as well, taking into account what he said. I think Siri is talking to me. She wants to vote.
You said we take it serious.
That's what it was, yeah, that's right.
Mr. Chairman, if I may, I just wanted to address the commission's concerns about precedent and eroding the code, and I absolutely understand your concerns with that. But land use law and jurisprudence is a sort of fickle thing, and there's a balance between the rigidity of sort of the bright lines that everyone would like, with the flexibility to allow property owners to use their property how they would like. So over the years, case law has developed that says that, whether for certain issues in land use, that it's not just specifically rigid, that the code says X, so therefore it's X, and no matter what, you can't do Y. Therefore, over the years, case law and different statutes have allowed modifications, and it's not just willy-nilly modifications based on some arbitrary standards on how you feel on this particular day. It's modifications based off of usually specific enumerated factors that you have to take into consideration. So it's not so much as eroding the code or eroding the authority, it's using your authority to come up with what you feel is best. So I just wanted to leave the members with that.
And, Mr. Rahman, thank you.
That's
I was
great.
trying to say that, you just said it
Yes.
better than I did, and so I appreciate that. I was trying to give fidelity to the code, including the modification provision, and the factors that we're supposed to take into account when we exercise discretion. And so, with that, I think, go ahead, Janice.
No, I was just going to say, Matt's concern about future development, I don't think that's something that we should be factoring in here. That's not part of what this request is about. So, it's legitimate, but I
It's not
don't think
exactly
that's
before
for a
us.
future time, I think.
Yeah, I'm going to kind of cut off the comments. I appreciate you raising your hand. I think it's with us now, and I think we're probably at a point where, in all fairness to everybody, we ought to see if somebody wants to make a motion one way or the other, see if there's a second. If there's not, somebody can make a motion in the other direction, see if there's a second, and see how, I think everybody's made, a couple of you are on your fence a little bit. Now it's time to stop fence sitting, and, well, you can abstain. But this is an important issue, and to take a vote.
Okay, I make a motion that we reduce the requirement from the 12 feet to 10 feet for for M210046 Hinman property for their right-of-way, or their use in common driveway.
Okay, so we have a motion basically to agree to the requested modification.
Correct.
All right, is there a second to that motion?
I'll second that.
Okay, we have a motion, we have a second. Is there further discussion? Now's the time if you want to raise another issue. All right, then why don't we take a vote, a roll call vote, please.
Mr. Hoff?
I'm going to abstain. Just say
Ms. Kirkner?
Yes.
Mr. Lester?
Yes.
Mr. Kane?
abstain.
Mr. Smith?
I think I'm going to abstain too.
So, as a matter of, does that
Yes.
pass?
Or, yes.
Well, 2 are in favor, 3 abstentions, so I believe in this case, the chair would need to vote
Yes.
to make the decision, because we need the majority of the members.
Okay, I vote yes.
All right, please let the record reflect, 3 are in favor and and there are 3 abstentions, but the motion passes?
Passes with 3 majority votes.
Yep.
Okay, so your
Yes
modification
votes.
request is granted.
Thank you. I appreciate
Thank you very
it.
much.
Thank you for all your time. Sorry it took so
Welcome.
long.
Good luck, be good neighbors.
Thank you.
Thank you for the in-depth consideration discussion.
Very welcome.
Who was the three?
Thank you so much.
It was a discussion for us for a
It
lot of
was,
reasons, and I appreciate you guys doing
Mr.
that.
Smith,
My pleasure.
Kane.
Good stuff. That was a good conversation on a lot of different,
It was
these modifications
Lester,
are eating me alive.
Wathers, and
Yeah,
Kirk.
they always will.
I was hoping for 2 no's.
Do we have a recess?
We do have a recess.
Okay, we're going to stand in recess. We'll come back in 10 minutes. Everyone, we'll go back in session and move on to item number 12, which is the Collins property, and it's case number P-22-0033. It's still morning, so good morning.
Good morning, Amy Barcroft with the Bureau of Development Review. I'm here with the engineer and developer. I'll let them introduce themselves.
Hi, yes, I'm Linda Alexander with CLSI. We're the engineer of the property.
Mark Frizera with Clear Ridge Developers, the owner and developer.
Thank you. The subject property is located on the west side of Hodges Road, north of Bartholomew Road, Election District 5. This plan is before you today for a consideration of a request for modification to the maximum number of users for the use in common driveway in a residential zoning district from 5 to 6 users, and action is required of you today. The subject property is 15.77 acres north of Bartholomew Road, near the intersection of Hodges Road. It lies in the R20 zoning district, like most of the properties in the surrounding area. To the north lies 29 acres, which was previously conveyed from the subject property to the Carroll County Commissioners for Hodges Park. In 1971, a 4-lot subdivision for the subject property was approved, and it's known as the Sterling Collins development. Those 4 lots border Hodges Road on the eastern property line. The plat recorded for that small subdivision included 50 feet for future roadway, and that was noted on the plat, between lots 2 and 3, and that maintains access to Hodges Road for the remaining land. The property is inside the existing water service area, but outside the sewer master plan with no future service planned. The property lies inside of both the priority funding areas and designated growth area. On July 18th, a formal request from the developer was received by the Bureau, accompanied by a plan of future subdivision depicting 7 new lots and 1 existing building right on the 15.77 acres. This request compels the Commission to consider a modification to the county code, which would increase the maximum number of users on a newly proposed use in common driveway from 5 to 6. The maximum number of users on a use in common driveway is 5 in the residential zone according to the code. This relates again to 155025, which you are familiar with, the use in common driveway standards and criteria, along with section L for modifications, where the Planning Commission finds that because of unusual circumstances, shape and topography, physical conditions of the proposed subdivision, or nature of adjacent development, extraordinary hardship may result from strict compliance with these design requirements. All the lots will have a private septic system, and the Health Department will approve up to 7 new lots. This proposed use in common drive will be constructed 16 feet wide with a cul-de-sac at the terminus and is proposed to serve 6 lots. This is above the standard 12-foot required width. A pullover is depicted on the plan near the midpoint of the drive, and that's required for drives exceeding 500 feet in length. The proposed length of this drive is 750 feet. 2 additional lots are proposed. They will front Hodges Road and are proposed with single-user driveways. The waiver request package included a letter of request from the developer and the plan. It was distributed to Resource Management, Office of Public Safety, Department of Planning and Engineering for comment. All agencies have responded with no objection to the relief request. Engineering review noted that this is contingent on site distance being achieved. Currently, a stone mailbox not owned by the developer impedes site distance to the left, and it would need to be relocated or removed. My understanding is discussions are underway with that owner to relocate the mailbox to obtain site distance. The staff and developer are requesting a determination from the Planning Commission today regarding the request for modification of the number of users from 5 to 6. And once a determination has been made, a concept plan of the subdivision will be reviewed by technical agencies and will come before you again for concept approval. Thank you.
Thank you. Would you like to add anything?
Just that we put a lot of our reasonings for the request in the letter that we sent. So we don't really have any other information to add, except that we did speak to the homeowner that has the mailbox that's a question. And we are going, during the process, we're going to be probably relocating his driveway so that there would be adequate sight distance. That would need to happen whether we were putting 6 users, 5 users, or 3 users on this driveway. So it was something we'd have to deal with. The reason that we've asked for the request, we haven't completed the perks yet back there, so we did end up with some bad area that you can't, the plan shows some black holes, which you're not really, on your information doesn't show it, but there's a heavy water table down through there. So accessing through that environmental area to put any additional driveways or any other use in common would be a stability issue, as well as just a construction situation for water lines or roadways, any stormwater management. So to minimize any of the environmental impacts and to minimize any of the forced conservation removal and stuff like that, we felt that a use in common driveway with the 6 users was still the best option versus some type of public road or multiple use in commons to get back into there. And we're here to answer any questions.
Certainly. No, we appreciate that.
Just for clarification, so the common driveway will service 5?
Okay, so right now, we can come in with 5 users on that driveway. We're asking for an additional 6 house on there. The normal driveway would be a 12-foot wide. We're proposing a 16-foot. We are putting a cul-de-sac, when we say cul-de-sac, we're putting a roundabout at the end of that would allow for the fire trucks to get around, any heavy moving equipment, whatever would need to come back that driveway, delivery trucks or whatever, can get around that turnaround at the end is just as big as a cul-de-sac is at the end of a public road.
And then there's 2 other residences off
Yes, they're off of Hodges Road.
So there will be a total of 8.
Yeah. Mm-hmm.
Any other questions?
No, I was just going to say, our concern is the use in common right-of-way that we're looking at
Right.
here.
Right.
Okay.
Yeah, so in this case, the issue isn't the width. Width looks fine, it's the number of users. But in some ways, it's still not in some ways, it's still the same standard that we have to look at under the same modification provisions. So we're still distilling it down to the same issue of extraordinary hardship, taking into consideration the circumstances of this property and the number of users, not the width. If I've read the report, I read a lot of stuff for today, so I might not be remembering the details, but if you stuck with 5 and you added another driveway somewhere else, was that an option in this
So
property? Am I
the way the
misremembering?
property lays out, and you can see the perk areas that are along Hodges Road, those houses fit pretty well. In order to get that other lot, you'd need to cram a 3rd lot along Hodges Road, okay? Significantly reducing the lot width, which right now would be smaller than some of the other lots that are along Hodges Road, because the existing subdivision obviously was developed in front of us with certain widths. So there becomes a question of whether there's enough room to actually do that before you'd start running into the same situation where you're running into perks that wouldn't perk along there because of that water table that's coming up through the property. We already have lost, we initially had 7 users coming into that use in common driveway. But based on the perks that we have done already out there, which were amazingly were done in June, and we still hit a heavy water table of about 5 feet. Those black holes all signify water table problems, so there's not gonna be any more perks down that way. So we looked at a possibility of sticking within the use in commons, but then we were running 2 of them in, and it didn't feel like a community at that point. You had lots backing up against the use in common driveway as opposed to facing it, and had driveways on each side of the houses, and it just did not lay well for having that community of those little houses back there. Well, they're not gonna be little houses, but the houses back. That's kind of where we put it in. The other thing was, when coming up through those existing houses that have been there for years, it's pretty flat. we wouldn't be putting any type of public road up through there. We'd be putting nothing more than the wider driveway that they're kind of used to seeing anyway. So we were trying to keep the impact to those homeowners down by putting the larger use in common in, but not a full-blown public road to get back there for literally one more house. So it's just, that's kind of the considerations, and a lot of it was environmental.
Right, that's what I was going to say.
Yeah, a
Lynn.
lot of it was an environmental consideration. When this property was originally zoned R20 years ago, it's been zoned like that for the last 30, 40 years. I'm sure at one point there was probably going to be public sewer, and there was an intention for public road. That never happened over the years. And it's a pretty mature woods back there, so, that was
So,
the
so
main
the
reason.
intent, so if we were to run a second use in common back through the other road frontage area, that's when we would get into that environmental area. We'd likely not be able to get the perks we need, and we'd be putting a road and a water line and doing construction in an environmentally sensitive area that might not be stable, as opposed to, keeping that area in forest retention. So that was the idea. And I think the area where we're proposing to put this driveway, you can see it on the picture there, is the picture down
Yes.
below. It already has an existing, I guess, an entrance, so it's been well recognized for years that there's going to be a driveway going through there.
Let me just ask, are there any members of the public that would like to speak on this matter? Yes, sir.
Not really the public, but Marty Hackett with CLSI. Guys, this is a very unique situation. We have a piece of property that's zoned R20. All the lots are going to be on well and septic. If the same situation was either agricultural or conservation, they allow 7 users all the time. These lots are basically the size equal to what you see in those zones. So it's, and maybe Linda touched upon that while I had to step outside, but, so you have a developer that wants to widen the driveway to accommodate, the extra user. Well, in those other zones, they could go to 7 and still have a 12-foot driveway. So we just think it's a very unique situation, and it works well. Thank you.
Thank you. Thanks, Mark. Any other members of the public that would like to speak on this matter? Particular questions?
I'll just say something real quick. I mean, I saw the drawings before I looked at the one map that has the blue line on it, so, because I was thinking, okay, well, you could have added one of those houses to come out on the other side, but, I think with the extra width of the driveway, it's probably the best for everything. It's impact.
And the turnaround.
Looking at what, under the code, I don't know if you were here for our last discussion. So, what sort of satisfies the code, at least in my mind. I think your letter does a nice job of setting that out, and I appreciate you submitting that. And so I don't necessarily need to read all that into the record, but to my eye, and also what Matt said, when you look at sort of this particular property and how it's set up, which we always do in every case, to me, it seems like the extraordinary hardship standard is met, largely because of I accept what you've put in your letter, and I think that does a nice job of articulating it. So, if there are no other questions or comments, the chair would be happy to entertain a motion to either accept the requested modification or to deny it.
I move we accept the modification as proposed.
I second.
Okay, so we have a motion and we have a second to accept and approve the requested modification. Is there further discussion? We probably should do a roll call here for consistency.
Okay. Mr. Huff?
Yes.
Ms. Kirkner?
Yes.
Mr. Lester?
Yes.
Mr. Kane?
Yes.
Mr. Smith?
Yes.
Please let the record reflect that 5 are in favor and the motion carries.
Thank you all very much.
Thank you very much.
We're going to move on to item 13, which which is a concept site plan. This is for 1332 London Town, and it's case number S-21-0027.
Good morning.
Good morning.
Good morning.
Good morning.
Yeah, it's still morning.
I know. Surprising, isn't it?
David B. Kraft, Bureau of Development Review. As stated, I'm before you with the next project on the agenda, which is 1332 London Town, file number S-21-0027. Joined with me are a couple representatives with this project. I'll let them introduce themselves.
I'm Dennis Boyle. I'm with McKenzie Commercial Real Estate. I represent the leasing for the project.
Kelly Miller, attorney for the developer, 73 East Main Street, Westminster, Maryland, 21157. Thank you and good morning.
Bruce Lawler, representing the developer.
Marty Hackett, CLSI.
Welcome to everyone.
So what this project is proposing is essentially, it is proposing additional paving areas for parking and a contractor's equipment storage yard on the sides of the buildings. And we'll get into that a little bit more. As stated, this is before you as a concept plan. There is no action required by the commission with this. However, as with any site development plan, the planning commission may delegate approval of the final site plan to the planning commission chair. So for those who may be unfamiliar with where this is located, as stated, it is at 1332 London Town Boulevard. This is down in the Eldersburg area. If you're looking at the map on here, this is London Town. This road right here is Georgetown Boulevard. This is Maryland 26, and this right here is Maryland 32. And so the property in question is comprised of two separate parcels, parcel A, which is here, and parcel B, which is here. Both of those total roughly 35 acres, and they were recorded back in 1975 within the London Town Manufacturing Company subdivision. Both properties lie within the light industrial I-1 zoning district, and there are two established access points onto London Town from the properties. So the first one is located here, and then the second one is located here. So parcel A, the larger one, is currently comprised of a 284,000 square foot, two-story multi-use building. So there are various uses within this building here, and there are multiple tenants comprised with those various uses. On parcel B, which is this one right here, this is an 81,000 square foot warehouse. And the two buildings are currently connected by a gangway, which you can kind of see right here. There's also a stormwater and fire protection pond on parcel A, as you can see here. There are two freestanding signs, which I'm going to go to the next slide here. So each sign is at each entrance point. So this sign here is roughly 23 feet tall, and this is at the the western entrance. And then this sign here is roughly 12 feet tall, and this is at the eastern entrance. So I'm gonna go back here, go back one more. So if we look at some of the adjoining properties, besides the property to the north, which is Merritt Properties, and the property to the east, which is the Beatty property, all other properties that adjoin this are within that London Town Manufacturing Company subdivision. All adjoining properties are in the 2018 Freedom Comprehensive Plan. They are zoned either light industrial, commercial high, or residential 20,000, which you can see that would be the Beatty property over here. If we're looking individually, if we look to the west of the property, that is the Eldersburg Marketplace, which is a planned commercial center. If we look to the east of the property, as stated, this is the Beatty property. It is currently undeveloped at this point in time. The northern adjoining property is a Merritt property, and this is currently being used as a warehouse. And then properties to the south across London Town are either not developed or there is one parcel with a stormwater management pond on it. And so we'll go back to this. So ultimately, the property is fairly flat. Both properties are fairly flat. There is a climb in elevation as you get to the back corner back here. You can also see that there is a stream that butts along this property line as well as a little bit on this property line here. But there are no FEMA 100-year floodplain designations on site with that. You can see there are some trees, essentially a wooded riparian zone around that stream, but the rest of the property is fairly open besides the improvements on site. And the subject property, as well as all adjoining properties, are served by public water and sewer. So before we get into the meat of the meat of the report here, I just want to give some brief history as to how this came to be at this point. So through the years, there have been 3 different iterations of site plans on this property. In 2006, London Town Distribution Center was presented to the Planning and Zoning Commission and was granted final approval at that time. The project proposed parking area extension to the north and west side of the existing building, as well as a building expansion on the rear of the building for trailer storage. Although the project received final approval at that time, it was not pursued. A year after that, in 2007, a project was submitted to the county for review in reference to modifications to this existing pond on site. The project was subsequently rescinded and was not pursued through the review process. And then a year after that, in 2008, Planning and Zoning Commission was presented with a project that was very similar to the initial site plan they seen, which showed additional parking around the building, as well as the building expansion, trailer storage. And again, although the project received final approval with that, it was not pursued. So ultimately, with this iteration of the site plan now, the developer proposes to construct a paved parking area on the west side and the north side of the proposed building. At the junction of these new pavings is a fenced and paved contractor's equipment storage for contractors' building supplies, which is for a future tenant that's looking to come into the property here. The proposed paving and parking areas are going to be tied to the existing areas that are on site now. So they'll have an access point here from this existing parking lot and an access point back here from this existing parking lot. There's no work proposed to the existing buildings on site, with the exception of doors and stairways that are either going to be added or removed to help tie in access points to this this proposed paving area. So what this site plan does, as well as propose this new paving area, but it also accounts for all uses on the property and it confirms parking adequacy. As stated, there's been various iterations of the project through the years, but we don't have an official site development plan for what's currently being used on the site now. So this site plan that they're proposing now not only allows them to move forward with what they're proposing, but it also shows the county that everything that is on site is per code regulations. Also, with this site plan, the owner developer is looking to classify both properties, so parcel A, which is the larger one, and parcel B, which is the smaller one here, as an industrial park. So per the zoning code, an industrial park is defined as the following, and I'm just going to read this verbatim from the code. It is a self-contained development area of primarily industrial uses that is cohesive with a common development scheme and approved as a single development plan, which may be comprised of multiple lots under certain circumstances. It should be noted an industrial park is only permitted within the light industrial zoning district, which this property currently is zoned. So with all of that, this request was sent to the zoning administrator for their determination. And after considerations and discussions with other county employees, the zoning administrator agreed with the request and found it appropriate to consider the site an industrial park. So, as well as what's being proposed on site, when this was submitted for review, it was noted that a portion of the parking area encroached into the London Town right-of-way area. And so with that, with what's being proposed now, the developer will also remove that parking area from the right-of-way, and they will have the proper setback of 15 feet from the London Town right-of-way, which is in compliant with code. Currently, there's no parking requirements specific to an industrial park. So with this project, a combination of uses and calculations were utilized and factoring in to figure out what is permitted and permissible on site. So it should be noted that these calculations are based on what the potential is for this property, not what's currently on site, but what could be put on site. And this gets very confusing, so I'm going to read a lot of this verbatim from the report. But ultimately, the potential uses of the property were split into one of three categories: either a commercial use, an industrial use, or a warehouse. And we have various calculations for each of those uses currently within the county code. So per the zoning code, commercial uses can comprise no more than 20% of the land area of the entire industrial park. So what was provided was the square footage of what can be used as industrial and what can be used as commercial. That came out to be roughly 180,000 square feet. They took 20% of that to determine what could be used for commercial uses, and they applied the commercial use calculation to that. They then took the remaining 80%, which could be used for industrial use, and utilized the industrial use calculation for that. And then finally, what was left over was about 185,000 square feet of warehouse, which utilized the warehouse calculation. With all of that being said, after performing all the calculations, it was deemed that 684 parking spaces were required on site with what could be used on this industrial park. Of the 456 existing parking spaces, about 131 spaces were being removed to either allow the connections to the additional paving or as part of removing that paving from the existing right-of-way. The remaining 325 existing parking spaces, combined with what was proposed as 359 parking spaces within this additional paving area, it results in 684 spaces required. So it's right on the money as far as what they need to be code compliant. As parking spaces are for the benefit of both parcels A and parcels B, parking easements and cross easements for access are shown on the site plan and are going to be recorded with the final site plan. Another item with this project is that it is currently crossed by a planned major street, which is Georgetown Extended. As the design for Georgetown Extended is currently outstanding, we don't have a final design for that. There is an estimated approximate area of dedication depicted on site, which you can see by this line here. And so as things move forward with the site plan, we may modify that to if there's any improvements in the current design for Georgetown Extended, but that is what's being showed, and that is what will be provided to the county for the right-of-way for that. As well as that planned major streets at the intersection of Georgetown Boulevard and London Town Boulevard, which is here, is a proposed roundabout. As the existing access, the easternmost existing access to the site may be too close to that roundabout, as part of this site plan, they are showing to relocate that further west, away from that roundabout. Although it's being shown on this site plan, it's going to be performed at a future time. I believe it's stated that that would happen simultaneously with the construction of the roundabout. So they're showing it, but they're not going to do it at this time. So per county code, whenever you have new parking areas, especially when it's going to be used at night, then you have to have adequate lighting. A site lighting plan for the new parking area is provided within the site development plan. Pole-mounted lights are proposed, and they are proposed to stand at a roughly 12 feet tall, above grade, and building-mounted lights are also proposed and will also be mounted about 12 feet above grade, which you can see this photometric plan provided, and again, is provided within the site development plan package. So with all of that, the plan is exempt from code requirements of floodplain management. Water Resource Management has granted conditional approval with additional comments to be addressed during the final plans review. The requirements of Forest Conservation Ordinance were adequate for concept approval, but will require additional information during the final plan review process. Approval was granted by the Carroll County Health Department as well as the Bureau of Utilities. A new water line and utility easement is being required for the benefit of Parcel B. So if I go back here. So currently a water line from London Town serves both parcels. That isn't in compliant with current code, and so the Bureau of Utilities is requiring an additional water line to be run for the benefit of Parcel B, which will be constructed with the site development plan. Site compliance has stated that the site plan complies with the requirements of Maryland Accessibility Code. The Office of Public Safety has granted approval of the plans. Engineering review has granted approval with a traffic impact study not being required. To achieve site distance at the western entrance, the current sign that is there is going to be relocated so that it doesn't block your field of view looking down the road. Concept stormwater management approval has been granted. Stormwater management requirements for the new paving area are being addressed with a submerged gravel wetland, which is located back in the corner here. In their review, the Department of Planning determined that the proposed plan is consistent with the 2018 Freedom Community Comprehensive Plan, land use designation of light industrial, and with the Water and Sewer Master Plan. As London Town Boulevard is identified as a future sidewalk connection within the Bicycle Pedestrian Master Plan, a 5-foot sidewalk is proposed along London Town Boulevard, which I believe this spans the entire frontage of the property. Planning staff also included a recommendation to construct internal sidewalks as well as internal crosswalks to help, I believe within the letter is stated, for pedestrian safety for that. And finally, the site plan is tested or will be tested and reviewed for adequacy of public facilities in accordance with Chapter 155 of County Code. And before we move forward, I just want to show some pictures of the site so that you have an idea as to how it looks now. So this bottom right picture is standing to the west of the building, looking back where the paving is proposed. These two top pictures are looking back, or I'm sorry, if you're standing where the contractor's equipment storage area will be, this is looking down the west side of the building, and this is looking down the rear of the building. And this is a shot of the existing parking area. Here's a couple more shots on the eastern side of the building looking at that connection. And this is that gangway that was mentioned earlier in the report. This is the existing pond that is used for stormwater management as well as fire protection. These three pictures here are of the western entrance. These three pictures here are of the eastern entrance. And finally, these are the two signs that are currently on site. Again, to help with site distance, this sign is going to be relocated to not block the field of view. So with that, I'd be happy to answer any questions. I'm sure the representatives feel the same.
Would you like to add anything?
Yes, just briefly. Good morning, everyone. Thank you for being here today for this concept review. I really appreciate David's staff report. I think he hit every point that we would have. He alluded to it, but I'll say it. The impetus for this site plan has been additional tenants in this facility that we need to accommodate, and so that's what initiated this process. My clients have only owned this property for the last few years, so that history of previous site plans that David mentioned was from the previous owner, and now it's under new ownership since then. We do not believe that there will be any substantial changes from what you see here to a final plan, so we would request that, barring any substantial changes to the layout, that you do give the chair the authority to approve the final plan. Like I said, with the caveat that if any of the county staff comments generate a substantial change to the layout, then we will be happy to come back before this board. But given the limited nature of this request, that it's really just to accommodate some additional parking and storage space in the rear of an existing development, we believe it's appropriate if this commission would be willing to grant that authority in the chair. Like David said, we are here and happy to answer any questions that you might have today. So, thank you.
Why don't we, are there any members of the public that want to speak to this particular issue? Looks like there are none. I have just a quick question. On the back, where you're adding the parking, is the idea that there are going to be doors for loading and unloading and that sort of thing? I'm just not real clear on what that space is going to be used for. And the reason I ask is if it is, I assume there are going to be trucks in and out of there that are going to run up and down the west side of it. I'm just trying to get a sense of traffic flow around the property and how well that works with this plan. Marty, you look like you
Yeah,
have something.
the actual, if you look at the rear of the building, you'll notice some access points to the building that are at garage height. Basically, they're gonna be at grade with the garage doors. They accommodate, we actually, if you notice the radius of the curbs, we actually have it set up for, to handle tractor trailers to back in there if they need to. So we did design for a larger truck. The actual, will be a travel way that maintains around that whole area, around the building.
All the way around the building?
Correct. Yeah, the storage yard will have gates, but they'll have gates on both sides, so that it can remain open during operation.
The area that's under the gangway, which is between the A and B, it looks like, is that paved? I don't remember what that.
That is all paved.
So traffic can move, so the traffic can move all the way around this building that's part of.
That's
parcel A?
correct. Yes, that's all paved. There's actually, it's actually the paving, it's a sea of paving out there. It's a lot of it.
There it is, yeah, the top right corner, right?
Yeah, so this is the gangway here. This is standing past that gangway. This is looking back at the rear of the building. And this is standing under the gangway. This is actually the shadow of the gangway here, looking back to the rear of the property.
Okay.
So as Marty mentioned, this is all currently paved. And as you can kind of see from the pictures, you do see some tractor trailers that are currently in here now. So they do currently use that area.
So would the idea be for the trucks to get to the back, the new parking area in the back, would they be driving under the gangway using that area, or would you anticipate them using the new parking area on the west side?
Yeah, I mean, that's what it looks like they're coming down. Is there a connection between 612A and 612B?
Both buildings, the smaller building to the, I guess would be the northeast, in what they call Area B, that's all connected by paving.
Okay. So basically, you could go around the back of A, take a right, come down under, like you're gonna go under the gangway, but then you can take a left and drive in front of building B if you want to?
Correct. And we have it set up where the storage yard, if the gates are closed, these areas that access the garage bays, the way they work, could act as a turnaround for any trucks, should some reason the gates be closed. So we both basically got to handle it both ways. We can either have through traffic, or we can have, if it's closed off, people can get in and out of those parking areas and have sufficient turnaround room as you're entering down between the two buildings.
People, tractor trailers or cars?
That's correct. It's probably, you're looking at a lot of more box trucks, but we have it set up for both.
Mm-hmm.
So why would it be closed? Because of whoever's in the storage yard wanting at?
The storage yard itself, just for security reasons.
Yeah,
And they could, Bruce,
So I would
Dennis could
envision-
speak probably.
Yeah, the tenant we have in place for that spot is going to be occupying that back, which would be the northwest corner of the building. So that storage lot would be, specifically for their use. So that would be locked for their use, but it would also, we would also have the ability to drive through that storage lot if necessary. But it would be a storage lot specifically.
So,
for
but
that.
they can prohibit that, is that correct? So we can't, they're renting that, that's their space, so they may not want through traffic?
Well, there's probably not a big need for through traffic there because the other tenants there have dock doors on the other side, which will be on the east side of the building. They are serviced by dock doors on that side, so the likeliness of any other tenant needing to get back, or drive through there is probably very, very negligible.
Yeah, so, and the storage area is the new paving in the back left, top left corner, right?
Correct.
And there are gates that would close that off potentially for
That's correct,
security.
for security.
But people can still come in they can drive up under the gang, even if that's closed off, they can come up and drive under the gangway in between the two buildings to access the back area of those doors if they want to, prior to these gates.
Yes, and they would basically, any deliveries or any truck traffic can pull into that area, back into those garage bays where the turnaround areas are, or the access to those if they just want to turn around. That's why if you notice, it's a lot wider from the parking spaces, from parking space to parking space. The travel way is a lot wider in that area to accommodate the turning movements.
Where is that exactly you're talking about?
David, if you can point directly back to where the access off the buildings, right?
Yeah.
As you're coming in here, there's two access to garage doors there. You'll notice that area is a lot wider, a little bit to the left, David, up. Yeah, that area right in there, you'll notice it's a lot wider than your standard 25 feet. And that is to allow the trucks to pull in, back into their space and then make the turn. So they're basically doing a 3-point turn.
Right, but there's room to do that. They wouldn't get stuck back there and have to back all the way out.
That area only serves two tenants. Both of them have loading access, which would be on the east side of the building. The one of them is on the corner, the other one's sort of L-shaped, so they have loading dock on one side and a drive-in access on the other. So you're only, the need for anybody getting back there is only to serve two tenants there.
And this is primarily a warehouse back here, right?
That's all warehouse, correct.
Okay, I don't think I have any more questions. Anybody have any more questions?
I guess I would ask David, from the county's perspective, with respect to that roundabout that's going to be constructed, does the county have what it needs to do that? Is that a part of this process, or is that totally separate?
So that is considered as part of this process. Like I said, we wanted to keep in mind that roundabout was coming in. That's why they're moving that entrance point. But when that roundabout's coming in, I have no idea. There are still a lot of communications that are happening between owners of neighboring properties, between county staff, Department of Public Works, and stuff like that. So there seems to be a lot of still kind of up in the air in reference to that. But the best that we could do when looking at this project is just make sure that everything on this property is able to handle what that roundabout will bring.
Okay.
Any other questions? I guess the one issue is, do you want to delegate final approval to the chair?
I
think so.
do.
Don't need to.
Okay, all right.
Well, put it this way, if there are any significant changes, I'll be bringing it back here anyway. but-
Yep, I will make that motion that we delegate the approval of the final site plan to the chair.
Is there a second for that?
Second.
All right, any further discussion on that point? All in favor?
Aye.
Anyone opposed? Looks like they've given me final authority to approve, unless you make big changes, which you can, but then I'll be bringing it back here.
Understood, thanks.
So thank you for presenting this, very thoughtful, and we appreciate you all being here.
Thank you.
Thank you.
I think the next item on our agenda is lunch, and so we will take a recess. It says an hour. Do you think we can do it in 45 minutes, or is that going to mess up scheduling for the
I
afternoon?
think because we've posted an hour, just in all fairness, to anyone that's coming for the concept site plan to be here, especially the public, I think an hour would.
I agree.
If you're
Okay,
okay
that
with it, thank
makes,
you.
that makes sense. Okay, so we'll recess until
12:30?
12:25?
Yeah. That's fine. Yep.
12:25-ish. Maybe 12:30.
All right, thank
Afternoon, everybody. We'll call the September 20th, 2022 Carroll County Planning and Zoning Commission meeting back into order for this afternoon's session. Something, we don't have afternoon sessions very often, thankfully, but anyway, we'll move on to item 15 on our agenda, which is concept site plan, Drill Tech, and its case number S21-0029.
Good afternoon.
Good
Planning
afternoon.
Commission. Okay. And again, I'm Kirsten Agarwal of Carroll County's Bureau of Development Review. I'm going to let everybody here with me today introduce themselves for the Drill Tech project.
I'm Jeff Ziegler with CLSI Engineering Company.
Bob Steer, Area Manager for Drill Tech Drilling and Shoring.
Jason Reinhardt, Project Manager for Drill Tech Drilling and Shoring.
Welcome.
Thank you very much. Thank you for being here today. Okay, so we have before you here is a concept site plan. Concept site plan requires no action at this time, just for concept review, okay? This is for Drill Tech, file number S210029. This is located right here where this red shape is. In fact, the entire red shape is the site. This is to the northeast area of the county, just outside the town limits of Manchester. That's this unfilled in area here. That's the municipal limits of the town. This is within the growth limits of the town. However, it's not being proposed to be annexed at this time, so it is being processed per county code, which is why it's before you here today for your concept review. It is zoned C2, commercial medium in the county. This is a principal permitted use in the C2 zoning. We can come back to this page in a minute, but, well, it's not much better. The proposed use here, it's currently an undeveloped field. The proposed use is an office and a vehicle maintenance facility for Drill Tech. The site here you can see is mostly just open grass right now. There's an area of woods along the northern and eastern portion of the site. Those areas are both on slopes. The northern portion here is of a higher elevation, and it goes downgrade as it approaches the stream. And this area here along Route 30 is the focus of the development. You can see from this view too that across the street to the west are residences. To the south are other commercial activities here within the town, as well as some residents within the town. To the east, in this location, it's owned by the town of Manchester. There's a couple of parks over there, I believe, the Pine Valley Park and Charlotte's Quest Park, as well as a couple, I think 3 actually, municipal wells for the town in this area and slightly to the north of it. And then to the immediate north, I'm going to back up a little bit too. To the immediate north, you can see that's still within the county. It's not annexed into the town yet. That's a mix of residential and conservation zoning that's currently undeveloped. So our focus is this C2 zone property here, highlighted in orange, which is the Drill Tech site. Everything in this, for this site at least, is private water and sewer, well and septic for this site. Not proposing any connections to public water and sewer for this site. So we're going to go to the site plan layout. I hope that you can see a little better on your screens and on your paper there. This is a little better. You can see here on this drawing to the west is Route 30. Slightly to the south of this is where Route 30 and Route 27 meet, to give you a little bit more context as to where we are in the county. So Route 30 borders the western portion of this site. You can see the building here on the western portion of the property. As I mentioned before, everything kind of from this point forth is downhill towards the stream and the woods start about here. So this will be the western portion, western half of the site is proposed to be developed. The Drill Tech office and the Drill Tech maintenance building for the Drill Tech vehicles. I will note too, from my understanding, and correct me if I'm wrong, the maintenance facility will be exclusively for use for Drill Tech vehicles, correct?
Correct.
So it will not be open to the public there. It's not like a Jiffy Lube or something like that. It's specifically for this business. The office building is on the western side here. You can see the small square. It's about 2,000 feet, or 2,000 square feet for the office building. And the remaining portion of the building is about 10,150 square feet for the garage. It's a little bit hard to see on this drawing, but you can see the driveway access for this facility is here on Route 30, on the southern portion of the site. It moves to the east, and then it fills out a bit to allow for maneuverability of the vehicles into and out of and parking around the site. In addition to the parking here, marked parking spaces and an accessible parking space for the office and for the garage, the workers, and so on. Around the site, you can see grading, some significant grading is proposed here. Like I mentioned, the whole site is on a hill. It's on a higher elevation on this portion and a lower elevation on that portion, so it's a bit of leveling out that has to happen here. You can see the grading that's proposed to occur will create 2 swales along the northern and southern portion of the site that lead to the eastern portion of the site where there's a stormwater management facility, which we'll talk about a little bit more when we get into the reviews. This is even harder to see, but there is a landscaping buffer area proposed on the western portion, as well as a few trees throughout the parking lot here on the landscaping plan. These are the elevation sheet for the building. As we were discussing before, you can see the office to the west, adjacent to Route 30. There's a smaller portion, again, 2,000 square feet. And it's significantly shorter than the garage building, which also allows for a sign to be installed on the garage building above the office building that will be visible from Route 30. The garage building's height total here at the peak would be 31 feet. For the office building, 16 feet. The siding is supposed to be aluminum, and the roof will be a dark, I believe that is a metal roof as well, a dark-colored metal roof. Beige metal siding, dark-colored metal roof. And around the perimeter of the building, lights are proposed as well. I don't believe I have a photometric plan, but the photometric plan shows all light levels being at 0 at the property lines from the building-mounted lights. As I mentioned previously, this is essentially just a vacant field at this time. You can see this existing gravel apron off of the edge of Route 30. This is the road that's visible in these photographs here. The existing gravel apron that's on site presently is the same area that's proposed to be utilized for the driveway once this is constructed. This is looking from that apron into the site. The building would probably be right about here. And the driveway over here, the parking area over here as well. This is looking from, I think you can see the apron right here, looking in the same direction. And this is looking from this hill point here back towards the apron, which would be over here. So as far as the reviews go, I will also note that the only sign that's proposed presently is the building-mounted sign. There's no proposal for any freestanding signs for the site. Up to our plan. Okay. So as I mentioned, zoning administration has reviewed this plan. It's a principal permitted use for this zoning district, and the plans have been approved from zoning. Stormwater management has also reviewed the plans. I mentioned that I would talk about that a little bit later. These swales here, one to the north and one to the south that wrap around the site, they're both part of the stormwater management plan. And again, they lead to the facility here. So the swales lead to the submerged gravel wetland. All 3 of these features will be lined with membrane material that will make sure that potential contaminants coming off the site are handled in a way that reduces any potential for contamination off the site. That's because this site is considered a hotspot according to stormwater management review and water resource protection codes due to the fact that it's a vehicle repair facility, so extra precautions are taken regarding potential contaminants coming off of that site and handled in a way that helps reduce that possibility. So Stormwater Management has reviewed this. They've granted concept approval for it. And of course, they'll review it again for final. We'll see more details come out for that when that review occurs. Water Resource Management has not yet approved the site. There will be an easement required on site as there is a stream, like we saw in the previous aerial photograph, that runs along the eastern portion of the site here. There will be an easement required in association with that that's not yet shown on the plans. Forest Conservation is essentially the same situation. Forest Conservation's granted concept approval for the site, which specifies that 2.48 acres of forest conservation will be provided on site, but it's not yet shown. But like we saw previously, again, this entire area around the stream and down on the slopes is all covered in woods currently, and is proposed to be utilized to accommodate that easement. Now, landscaping approval has not yet been approved. As we discussed, there's an area of landscape buffer here. From the letters we received from landscaping, it looks like that's supposed to be across the entire frontage of Route 30, essentially, in addition to a dumpster. There's a dumpster located in this corner of the site, a dumpster and a roll-off dumpster as well, that will require screening per landscaping's code. So that will be addressed as this plan moves forward. Grading review also has comments that need to be addressed as the plan moves forward, but Soil Conservation has approved it as it is. Site compliance for accessibility has not yet been granted. The parking lot does show an ADA parking space as required, but my understanding from reading the letter, additional details are required regarding signage and ensuring that the access path into the buildings meet the code requirement. Fire Protection also has not issued approval for this site yet. Fire Protection issued a comment letter regarding the need to add a sprinkler system to the repair garage as it's over 5,000 square feet in size. This comment would need to be addressed prior to final approval, so we'll see a response from that in future submittals. As I mentioned previously as well, the site utilizes private water and sewer. There's a well and septic features, as well and septic on site currently existing. There's an additional backup septic area proposed that the health department has reviewed. They had additional comments as well, and we'll see that addressed as this moves through final review. State Highway Administration, again, also reviewed this because it's adjacent to Route 30 and connecting to Route 30. The State Highway Administration has some detail level comments at this time, but their previous comments regarding sidewalk and regarding the access point to the site have been addressed. Again, the access site's proposed on the southwestern portion here. And there's a sidewalk that runs from property line to property line, a 5-foot wide new sidewalk that will be installed also in association with this development. Planning reviewed this as well and found the proposed land use consistent with the master plan and the designation of commercial medium. The project was also sent to the town of Manchester. This is right adjacent to the municipal lines, so they also got an opportunity to review it. The town had comments regarding the wells that are in proximity to the site and down gradient of the site, the potential impact that this could have on the wells and on the stream. And like I mentioned previously, and I've had discussions with them to this point as well, the fact that this is treated as a hotspot, that there are additional precautions taken because of the fact that it's a vehicle repair facility, and the lighting that they utilize and the methods they utilize to handle the stormwater management. We've discussed that with the town, and they didn't have any further comments after that. So, but those were the comments that they had. Now, this site, of course, was also presented at the Technical Review Committee meeting, as is standard for any site plan. This was done on December 27th, 2021. There were citizens that spoke at that meeting. We received some phone calls and some emails. I believe you would have received in your packet there, some of the emails we received. The comments we received at that time from the public were concerned about traffic congestion, particularly on Route 30, potential impacts to the stream on site, and visual screening of the site for the residences, in particular from phone calls from the neighbors on the western side of Route 30 there. We also received, since that time, a few more phone calls, more or less to the same point, concerns about the wells, concerns about the streams, concerns about traffic on Route 30. I've also, since your packet was prepared, received 2 emails from Mr. George Hopman regarding concerns about the environmental impact for a vehicle maintenance facility featuring oil changes, lubrication, washing, and oil and diesel storage on the site, as well as, and that was in a letter, an email to the health department with concerns about that, as well as an email that was sent to the State Highway Administration regarding traffic on Route 30. So those were the 2 emails we've received since you had your packet, and phone calls along a similar frame of reference there. So all in all, there were a few agencies that still need to review for approval. This will be reviewed by all agencies when the final plan comes in. At this point, this is the concept review, so we'd be happy to answer any questions or address any comments that you or the public might have.
Thank you. That was very helpful. Any comments you all would like to add?
Not at this time.
Kirsten covered it pretty well.
Yes.
So, how would you address some of the concerns about the environmental impact and the wells and potential impact this could have on that? If somebody has a concern about that,
Sure.
How would you respond?
As far as the wells, for the county wells or the city wells that they're being used, we can provide self-containment on all areas within the shop and recycle any water, et cetera, and make sure that it's even clean of any contaminants before it would go to the stormwater containment area. As far as any fuel stored on site, we do this on all of our construction sites where we have double containment on all diesel fuels to where if there was a spill on the initial containment, the secondary would contain the entire amount with it that's being stored in the primary containment. I mean, like I said, we work on sites all over the country to where we have the potential to impact the environment, and we follow all procedures to make sure that that does not happen.
And there's a stream, obviously, that runs down along. Is your answer in terms of taking good care of that the same?
Absolutely. I don't even want to get, I don't think we're going to get near the stream. We would just make sure that we would contain any runoff before it even approaches that area.
If I can add in, the way the site was designed, there is no curbing proposed. Everything from the pavement runs off the pavement and into the swales that, run around the site to the south and to the north, which then ultimately go into the submerged gravel wetlands, which Kirsten did say that it is a lined facility, so there is no potential for infiltration into the ground from that. But it will, part of that will have a sand filtering system that will filter out some of those contaminants before it gets into the retention portion of the pond before it's released. The site is 16 acres, but it has, a wooded, approximately a 4-acre wooded area around the eastern side of the site. We are not impacting any of that woods, and all of that will be put in forestry easements or variable stream buffer easements, so none of that is being impacted. And, they're going to be concerned about their own well on site and the contaminants that go into the grounds or, coming off of their site. So they want to look after themselves there too.
Thank you. And then the other concern that was raised is from members of the public were traffic. So let me just ask you to address that if you would.
Sure. Most of our traffic employees would be arriving, between 7 and 8:30 in the morning, leaving between 5 and 5:30 at night. Any traffic that would be bringing in the vehicles or equipment Usually occurs early in the morning or in the afternoon. We don't want our trucks involved on Route 30 during heavy traffic situations. And most of the time, if our vehicles and trucks are going out of that facility, we're starting work on our sites before 7 a.m. So they're usually gone much earlier to where it wouldn't impact any existing traffic.
How many employees do you anticipate having on site?
I would say peak employees would probably be 12 to 15, somewhere in that area.
And is it right that immediately adjacent to you is it Rohrbau Bus?
Yes.
Company?
Correct.
Okay. And that's right next to you, I think.
Yeah, I don't think they're a bus company. It may still be owned by the bus company.
They're not
But
using
what
it.
they're doing right now is they transport dry goods through tanker trucks. So,
Any other questions that you all have about the property?
Looking at everything, have you, because obviously they said it's going to need fire protection, do you have an idea of where you're going to set the tank? Because being on well water, you're going to need a very, very large tank to supply the sprinkler system, and it needs positive flow going into the building, positive grade. You're probably looking at least a 20 to 30,000 gallon tank just for the sprinkler system alone.
yeah. We
So-
can either elevate the tank or keep it at grade and use pumps.
Well, yeah, you are going to need a pump. You're going to need a pump house. You're going to need
No,
all
I'm
that
saying
stuff.
pumps from the tank to the sprinkler system.
Yeah, so what you'll have is a vertical turbine pump that will sit over top of that, yeah. But looking at the site plan and the way it's all grading, knowing you need positive pressure going into the building, I'm just kind of curious as to where you guys are thinking that that's going to go, because it's pretty jammed in there.
Ideal, we can put it up on top of the hill. Looking at the site, the way it's on the plan right now, we could put it up on the hill on the south side
on the south side
or
or the
on the
north
north
side.
side.
Yeah, and I'm just
Either
bringing this
one of
up
those.
because, being on well water, that's going to be, maybe you are prepared for the expense of that. I just have experience in that industry, so just something to keep in mind that is going to be a requirement, so.
Absolutely.
Yeah, commercial property in Carroll County wells are definitely a little more expensive than just public, but that's something the engineers and your people will be able to determine.
I would love for the town of Manchester to give me a water and sewer hookup permit, and we wouldn't have that
Yeah.
conversation.
That would be the ideal, but
So is it the case, Kirsten, that we're gonna see this again with a more detailed landscape plan showing the screening? I'm
So-
changing the subject, sorry.
No, it's okay. With site plans, there's always the choice that can be made at the concept presentation for the commission to delegate approval to the chair. If that happens, if you choose to do that, then you will not see it again, and only the chair will see it again. However, if you don't make that motion, you will see it again for final, yes. And that will be after all county agencies have already approved it. It will be more or less the way that it's going to be. That would be what we'd be approving.
And the landscape comment, our landscape buffering that we proposed was between the parking lot and the office area. We created sort of a small berm with the landscaping in front of there. Jonathan Bowman wanted us to extend it further north to make sure it was between the edge of our pavement and Route 30. We didn't do that initially because it sort of goes up the hill, and it creates a national, or a natural buffer,
Yes, sir.
the way that it's graded, so we didn't take the need for that, but we can certainly extend it for him.
I think there's enough things that still we want to see before we would just say, give it to. But I promise, we'll do it quickly.
I will note too, while we were just talking about landscaping, the one phone call we received from the neighbors to the west was a household that was right about here that was concerned with screening somewhere in this area. Probably have a good drawing.
Yeah, and I'll just say that from my perspective, the screening that I'm interested in seeing is the screening of the dock areas. Because it's a cross-dock facility, you got stuff all over the place. That office frontage might actually be appealing if you do it right? And so you might be able to take some of that landscaping and just, move it to the sides, and show your logo. So I'm up for that, but again, I think if I was living across the street, it would be nice, and I get the light wash and that it's at 0, but still, it'd be nice to have that, that screened a little bit, those dock areas screened.
Are there any members of the public that wish to comment on this project? All right, not seeing anybody.
Wait a minute, wait a minute.
Here comes one. Yeah, come up to the microphone here, please, and state your name and give us your address.
Randy Miller, Secretary, Board Member, and Volunteer at Charlotte's Crest Nature Center at Pine Valley Park, Manchester, Maryland. So you have addressed many of the current concerns I had pretty adequately about the traffic, so I'm going to omit that part of what I had planned to talk about. But I had spoken, and this is in regards to the potential for like spills or malfunctions at the facilities, because accidents can happen. I had spoken with David Robinson of Environmental Health, who primarily deals with septic and wells concerns. He had the impression that this location was to consist of an office and vehicle storage. And then my understanding was that, and this was just described as well, that this area or site will feature heavy vehicle maintenance of industrial vehicles, featuring, I believe you had said this, if I'm repeating myself, I'm sorry, or repeating anything already stated, I do apologize. But oil changes, lubrication, washing, and oil and diesel storage, which will require a water treatment facility, which David Robinson didn't seem to be informed of before Mr. Huppman. George, you had mentioned him earlier, a bachelor's in environmental planning, had brought to his attention, which does raise possible concerns of honesty and transparency on behalf of Joltec. Other concerns raised by other board members and residents of the area are the proximity to the wells on Farrier Road, and then Trout Unlimited Stream, which does provide future drinking water for Baltimore County. And then also the adjacent Pine Valley Park, which includes natural habitats and various land, wildlife, and plant life conservation efforts. There are various species of wildlife, vegetation, including 30-plus species of trees, located at and behind that tree line, just behind and below the proposed site location, within that wetland area, and all of which could potentially be threatened by the construction and operations of this facility.
Very
Those
good. Anything else that you'd like to raise?
Those malfunctions relating to like a runoff and similar
Right.
issues, but that is all. Thank you for letting me speak.
Sure. Thank you. Anyone else have any comments? Yes, sir.
Tom Smith, Manchester resident. My concerns are similar to what you just heard. A couple other things I want to reflect on, though. The 2004, within the park limits, the whole school of Manchester Elementary, 700 students, participated in a buffer area, planting of 185 trees right along the stream. So the concerns were back then as well about keeping the stream clean and working for the environment purposes. Mentioned Trout Unlimited. We had them come in some years ago and check the pond because some people thought the discharge water was maybe too warm for the stream. But they came in, and after several studies, they said that was fine at that time. So we want to make sure that any runoff that comes from anywhere else doesn't affect that as well. Talked about the sewer and runoff water in the collect basins. After it leaves the collect basins, can you clarify just what it's going to do from that point? Anyone?
So your
Drill
question
tech.
is where it goes from the basin
Yes.
onward?
I think that's drill tech must answer that, I guess.
Well, the stormwater, the outfalls in the existing grass area that has a little bit of a buffer overland before it gets into the wooded area that we're not, that we'll be protecting and leaving as it is. From the stream itself, there's over 200 feet from the outfall of our facility down to the stream. Most of that is through the wooded area, which, will serve as a nice filtering buffer.
And Jeff, you said the stormwater facility had filtering medium in it as well.
Correct.
Right, so if I understand correctly, it gets filtered at the site, and then once it leaves the, what I'll call a holding tank, basically, then it runs, as it does now, right, through the grasses, down the hill, through the woods. I mean, any water that runs off there now does the same thing, is that right?
Correct.
And the water temperature that he had raised, would that, to your knowledge, be affected by any runoff from this facility?
To my knowledge, it shouldn't be, because it'll be, again, it's a two-stage filtering process. Not only will, the water come through the side swales, that'll help cool the temperatures down, but it'll go through a sand filtering system within that basin facility before it gets released onto the ground.
Mr. Smith, you had mentioned 185 trees that were planted by the elementary school, I think?
Yes.
Those trees, I don't think, are being disturbed, and nothing about that.
No, but I'm saying that they were put in to help preserve the stream and the area from other runoffs and different things at that time, which is approximately 100 to 200 feet upstream from where this site area is.
Okay.
And that's the headwaters of the lower Gunpowder, the South Gunpowder River, South Branch.
Okay.
So that, like you said before, it runs into the Prettywood Reservoir, Loch Raven. That's all part of Baltimore's watershed, and then eventually into the Chesapeake Bay, and we know the problems that Chesapeake Bay is having. So that's just concerns there. One other concern I have is what you mentioned about traffic. You're saying that you're not going to have that much traffic going out at peak times. Well, I live in Manchester, just a few houses up from there. And the times you mentioned are peak travel. My driveway, anywhere from 4:30 in the morning to about 8 o'clock in the morning and even later, I can sit there 2, 3, 4 minutes trying to get out. And the only way I get out is somebody's kind enough to stop and let me out. So, and with the other truck depot there, right next to the adjacent site, they constantly have traffic backed up because they've got to make the wide turns, in and out, and traffic is always backed up there as well. When I say that it's backed up in the morning, traffic coming from the north, from Pennsylvania area, it can be backed up from 27, which is just up the street, all the way up to Lineborough Road, which is a mile, and even up above that to Ebb Valley Road, which is another quarter mile. And that's not uncommon on almost any given day. Now, not that it happens every day, but it does happen. And in the evening, traffic flying down that hill, trying to get home, it's really a headache. Try to get out and to maneuver around through there. So traffic is going to be a problem, and it's going to increase.
Very good. Any other comments that you haven't already mentioned?
Thank you.
Okay, thank you very much. We appreciate that. Do you all have any other comments in response to any of that? You don't have to, just.
I just would want to add about the heating of the water. From what I understand, that pond is a submerged gravel wetland. So the idea is that all the water seeps into the ground. So it's not going to, drain down the hill and warm the streams below.
But it will have a lining in it, so it won't infiltrate into the ground itself.
Yeah, and the traffic, I think any of us that drive up there know that it looks like they evacuate Pennsylvania every morning coming down that road, and certainly I'm sensitive to that. I mean, that certainly is the case.
Down 30.
I would just say as a commercial use, because it is zone C2, this is a considerably light commercial use with traffic as a concern.
Right, yeah, and I think we recognize that. I mean, you have 13 employees there, tops, so you have to get out into the road. Traffic's a problem for you too. But, so we certainly understand it. Any other questions or comments for? All right, well, it looks like we'll see the final plan as a group, once you have it all together, and we'll try to move that quickly. So as soon as you have it ready, we'll try to get it on the agenda and get it right back to us. We understand time matters, so we'll be ready to look at it just as soon as it's finalized. Okay, thank you all very much.
Thank you.
All right, we'll move on to item 16, which is a concept site plan, Cool Springs School. It's case number S22-0020. So, good afternoon. It's officially afternoon.
Good afternoon.
Welcome.
Good afternoon, Amy Barcroft with the Bureau of Development Review. This is project S22-0020 Cool Springs School. I'll let those with me introduce themselves quickly.
Mike O'Brien with Hanover Land Services. Joseph Lapp, School Board Chairman.
I'm John King, School Board Secretary.
Thank you so much. Thank you.
Thank you.
This plan is before the Planning and Zoning Commission as a concept site plan. No action is required. The Planning Commission may consider delegating approval of the final site plan to the Planning Commission Chair. Additionally, we are looking for some direction for parking requirements, which you'll hear later on in this plan. The subject property is located at 2318 Cross Section Road in Westminster, Election District 2. The 59-acre parcel is in the agricultural zoning district. We are northwest of the city of Westminster and east of the city of Tawnytown. This property is accessed by a 10-foot wide gravel driveway over an adjoining property with a platted right-of-way easement to Cross Section Road. The property and surrounding properties have private wells and septic systems. The property's environmental features include a stream, pond, woods, FEMA floodplain designation. As you see, adjoining properties are zoned agriculturally with several in preservation easements and most built with single-family residences. The developer is proposing a one-room Amish schoolhouse on 1.4-acre lease area in the northeast corner of the property. The plan proposes 2 new structures, a 1,320 square foot school building and a 35 square foot cement block building for boys and girls toilets. The proposed one-room school building will have a front elevation of 19 feet and a 2-foot bell tower. The maximum height in the ag zoning district is 35 feet or 2.5 stories, so this complies. A 10-foot wide gravel driveway is proposed to branch off the existing driveway to access the site. The zoning, the Chapter 155.078 of our code requires 18 feet wide minimum width for access drives to sites for two-way traffic. So our option in this case would be to seek an administrative adjustment from the zoning administrator, which I understand the developer and engineer are pursuing at this time. Schools are a principal permitted use in the ag zoning district. No signage or lighting is proposed on the site. 1 handicap parking space and accessible paths to both the school and bathroom structures will be constructed in accordance with site compliance review. Approximately 35 students are projected to enroll and all will be supervised by 1 staff member. There are no special events or assembly areas proposed. All students and staff will be dropped off by a group of 4 vans daily. No other vehicles are anticipated to use the site. This is proposed to generate about 8 average daily trips for drop-off and pickup. And the owner and developer are proposing 1 handicap accessible space. According to 155.077, the minimum number of spaces required for elementary, middle, high school, or equivalent private or parochial institution is subject to a detailed parking analysis and study, which shall address the following: the number of faculty and staff, the projected enrollment, requirements for special events, the capacity of special assembly areas, and the final determination will be made by the Planning Commission. Landscaping is not required for this project. Forest conservation is exempt. Stormwater management is being addressed by a microbial retention facility proposed on site. The drainage from the site discharges onto the subject property, which then drains into the MAP FEMA floodplain on the farm. Concept stormwater management approval has been granted. Water Resource Management and Floodplain have approved the plan. The site is outside the jurisdiction of the Bureau of Utilities. Zoning, site compliance, and emergency services have approved the plan. The plan is consistent with the Carroll County Master Plan determined by the Department of Planning. The Health Department has some outstanding comments to be addressed on the final plan, and the engineer has requested a variance for the required site distance at the driveway entrance to the property from the required 500 feet to 425 feet to the right. Site distance is somewhat hindered by the existing grade and a tree line on a neighboring property. The request is still pending with our engineering review. The concept plan was submitted in April 2022, and the plan was subject to citizen involvement at the May Technical Review Committee. 3 citizens were present at that meeting. 1 had concerns for trash disposal from the site and alleged that trash was being burned from the property. No dumpster is proposed on the site. This final site plan will be tested and reviewed with adequacy for public facilities in accordance with Chapter 155. Again, no action is required, but we are asking for direction for the parking requirements, and final approval can be delegated to the chair. Here are some photos from the site where it meets Cross Section Road, and the site itself is a farm field. Thank you.
Thank you. Gentlemen, have anything to add?
I believe so.
In terms of the, let me just run backwards. The one was an issue of trash disposal. What is the plan there?
Well, the children would have the role, they take their lunches to school and they're supposed to put their trash back in their lunches, but I know there's always gonna be some trash. We usually keep a burn barrel at our schools, and, you know, every once in a while they'll burn some trash, but it's not like it happens a lot.
And there were, did you say 35 students, is that?
I think we have proposed for 35 or 36.
And 1 staff.
And 1 staff member. Okay. The parking spaces, you were mentioning, and I know we've got it in our report, the number of parking spaces required will be subject to a detailed parking analysis and study, which we're not capable of doing, but it seems like we have 4 vans dropping off 35 students, and we have 1 staff member. How detailed does the parking analysis need to be? I mean, and there are no public events here. So how do we get to a place where we can come up with some ideas for what parking is required?
So we feel that it's a relatively low impact to the site. Obviously, it's not open to the public, where other schools might have a larger public involvement. Again, we're just looking for the Planning Commission to make some analysis based on the facts, the projected enrollment, the 8 average daily trips. and go from there.
Okay, and I'm not trying to put you on the spot.
Sure.
I'm just trying to get some guidance here in terms of what might be reasonable under the circumstances of the particular use of this particular property in this particular context.
I'm confused on the 35 square foot restroom, which, if my calculations are right, what's that, 7 by 5? Something like that. So there are no wells or septics on this property that are being required? So is this an outhouse?
Correct. There will be no running water to the building, and the boys and girls toilets will have tanks located below them, which will get pumped out.
Okay, so without any running water, what, and it's not for us to decide, but God forbid a fire, how is something like that addressed for the building, for the school building?
There is a pond on site, I believe, that they're deemed adequate for fire protection.
Is located actually directly across the driveway from the site is a stream, and then the pond is directly across the stream from that.
So that's where if there were a fire, the fire department could pump water out of the stream? Okay.
So I assume this is very standard size school and stuff that you guys have in different areas
Yeah,
of Lancaster County,
and
New York.
as far as the parking, what we have proposed here, one parking spot, that's what we've always were required in Lancaster, where we moved from. So, yeah, we're proposing pretty much exactly what we were used to building in Lancaster.
And the students will be dropped off, and then the vans will move off premises. So no, throughout the day, no vehicles will be actually parked there.
So, and there's no other employees, just one?
Correct. And Joseph actually let me know a little bit ago that the teacher that will be there actually lives on site currently.
So they don't need a parking spot either?
No.
Correct.
They'll be walking.
I would say the only thing I propose that maybe you add is maybe a pull-off somewhere on the driveway, because, you know, God forbid something would ever happen. You know, we know things have happened before that you could have an intruder come or something, just in case, you know.
Emergency vehicles or something?
Emergency vehicles or something, some kind of turnaround in case there would have to be, you know, something happen. I mean, it's always possible. Yeah, that would be like, you know, I think everything else is pretty standard.
And I take it your experience has been having the one parking spot has been fine?
Yes.
This is unusual for us, so that's why we're hesitating.
We're just, it's trying to wrap our heads around.
We actually built one last year in, on Rope Road, but we didn't have much grading there. It was a very flat area, so it was not stormwater, did not require stormwater management, and so it wasn't a full-blown concept. That's why it
Did
didn't
we
come
see
from you,
that?
but
Did we
this is
see that?
exactly,
That one, yeah, that one was a simplified site plan.
Oh,
this is exactly what we put there.
Okay. Well, I like Matt's idea of a turnaround, just, I mean, a pull-off. If you've got to get emergency equipment back there for some reason, you want to make sure that they can do it and get there. That's in everybody's interest to make sure that that can happen. I don't think under the circumstances here that presents much of a problem. I mean, it's a gravel road, and having a pull-off probably is not too difficult. Does anybody else have any other questions or comments?
I'm still on the 7 by 5 bathrooms.
Yeah, the others.
I'll jump in here just for a moment. I've worked with with Mr. Laps on several projects. I would assume there will be no electricity to this building, just like everything else there, correct? I would agree with Mr. Huff from a public safety standpoint. I don't believe 10 feet is enough. I think it should be, I don't like use in common driveways, so I'm going to let it go at that.
I
But
think this one's 18 feet.
Is this one 18?
Uh,
No, it's not.
Oh, it's 10.
It's
Okay,
10.
I'd written
10
18
foot
for some
existing.
reason.
So I was going to reference the 12-foot that we
12
use
foot.
for the use in common, but I'm not going to. But I truly do think that it should be at least more than 10, especially considering the fact that the pond will be utilized, if necessary, for fire protection. 10 feet is just not enough. So if there's a way that we could, I mean, this is just me personally talking now, that, you know, from the experience that I've had. So, and I'd also like to see if, has fire protection weighed in on this? Did you say that, or they didn't?
Yes, Emergency Services has approved the plan.
Okay, did they call for any static standpipe or anything on that pond, or did they just go with the fact that it could be drafted out of? What was, do you know?
I don't know any details about that.
Okay.
They did not require that.
As far as the existing driveway width, the platted right-of-way leading to through the adjacent property is, it's only a 12-foot right-of-way.
Okay.
So it would be very difficult to widen that driveway without acquiring additional right-of-way width there from the neighbors.
Okay.
I don't know how cooperative they would be with that.
I guess you said it's in a wet zone, didn't you?
And also, that section does run through a emergent wetland.
A what, a wetland?
Yes.
Okay.
I would probably propose maybe just widening that corner where you turn in there, instead of being 10 by 10 intersection, widen it so something could come in there if it had to, at least, and maybe just your new road be 12 feet. That wouldn't add much.
Yeah, I'd try to get as much out of it as you can. That's really tight. I mean, a fire engine these days is at minimum 8.5, 9 feet wide. So not a lot of room for maneuvering there. Not that, let's be clear, I hope we're never in there. But, you know, we've made some stipulations over time for the fact that there's no electric. So, and I know you guys will do that with the fire extinguishers and what have you, but I would encourage you also to reach out to the local fire department and have them come look at the pond, just so they know what they can and can't do there. And they might be fine with 10 feet, but, you know, at least get them involved, and I can certainly help you with that too. But, you know, that's something I think is important.
And the health department is still reviewing, is that?
They have some outstanding comments that need to be addressed on the final plan.
Okay. I gotta say, I am still hung up with this 7x5 thing. I mean, knowing children, I mean, when they gotta go, they gotta go. I would like to see a little, maybe 2 for the girls, 1 for the boy. The boy can go anywhere, but it's, you know, it's.
That seems discriminatory.
I know, I'm sorry. I just, health-wise, I just feel like it's.
Well, and don't take what we're saying to try to make something that's simple complicated. We're not, but we do want to focus on life safety issues. I mean, if emergency equipment needed to get back there, we want to make sure they can. So there are a few things, like you said, the health department still has to comment. Certainly the commissioner's ideas I endorse about talking to the local fire folks and just having them eyeball it and collaborate with you. Are there any other questions of the commission on this?
No.
Are there any members of the public that want to comment on this project? Doesn't look like it. And then the other thing is, do you want to consider delegating approval of the final site plan to the chair?
Yeah, I'll make the motion, we delegate the authority to the chair.
Second. All right, we have a motion, a second. All in favor?
Aye.
All right. Good luck, gentlemen. Thank you.
Thank you.
All Right. All right, next item on our agenda is a brief recess. We'll take 10 minutes and reconvene then. Thank you.
Great, thank you.
Everybody, welcome back. We're in the home stretch. No, we're not.
So
We got
far
another
more items,
recess.
we're not quite there yet.
Pretending.
Just a little bit of hope.
Pretending to be in
I
the
was
home
extending a
stretch.
little bit of hope. All right, well, welcome back. We'll reconvene our meeting today and go on to item 18. This is... Rezoning case 226, Max Suite property. And Ms. Weber, you're leading us on this again.
Yes, I'm back.
Welcome back.
Up next, we have the rezoning case 226 of the Max Suite property. You'll remember this was introduced to you all at your August 31st meeting. I'll let Clark Schaefer do his introductions.
Thank you. Clark Schaefer, 73 East Main Street, Westminster, on behalf of Max Suite, who is here with me today. Max is the owner of the property that is the subject of this rezoning.
Welcome.
And he's also a principal in the neighboring property known as Vanessa's Corner Pub, which is there.
Okay.
Marty Hackett, CLSI.
Okay, so before we jump right in, I want to give a brief overview of kind of the piecemeal rezoning process and what you all should be thinking about during the arguments and the presentation. So per Maryland state law, piecemeal rezonings can only happen if there was a mistake in the last comprehensive rezoning or there was a substantial change in the character of the neighborhood. So those are the two things that the arguments will be focused around, so it's just some things to remember. So getting into the actual case, we are in the rural village of Taylorsville, just a little west of the Maryland 26 and 27 intersection. The property to be rezoned is 7.716 acres. It is currently zoned agriculture, and the request is to go to C2 or commercial medium. The applicant is arguing both a substantial change and a mistake in the zoning. We are in Election District 14 and Commissioner District 4. The neighborhood boundary was established since there was they are arguing there was a substantial change in the neighborhood. So the neighborhood boundary helps us realize and confirm what the actual neighborhood boundary is and where the substantial change may have occurred in. So the neighborhood boundary is approximately 61 acres, and it's predominated by the intersection of 26 and 27. And inside, thank you. Inside the neighborhood boundary are a mix of uses from commercial and residential. There's mobile home park, there's gas stations, there's liquor stores, there's a lot of different types of uses inside the neighborhood boundary. And then the zoning is representative of the different types of uses that are inside the neighborhood boundary. So we have a mixture of C2, R40,000, and agriculture. And now here are the new informations that were not presented on the 31st. Per county policy and process, we send out a transmittal to county agencies for comment. And these are all of the different agencies that we sent the request for comment to. We received one advisory comment from David Robinson from the Carroll County Health Department. The proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses of this property. And we'll get a little more into the septic issues in the arguments. So as we said in the beginning, the petitioner is arguing there is a mistake in the current zoning. The petitioner alleges mistake because the zoning authority who planned and zoned the property for agriculture was unaware of the following facts and circumstances. The subject property is located immediately adjacent to the existing commercially used restaurant and bar, which is the Vanessa's Corner Pub, as Mr. Schaefer introduced. The petitioner acquired the subject property in April 2020 and is a principal in the real estate business known as Vanessa's Corner Pub. Vanessa's Corner Pub is the successor in a long line of restaurant bar businesses going back historically. The property has historically had septic and well issues involving significant review and regulatory attention of the Carroll County Health Department and is currently served by a septic system / holding tank, which needs to be pumped out monthly, if not more frequently. The subject property has existing driveway entrances onto Maryland 26, and the subject property, if rezoned, would be eligible to provide development opportunities which would provide relief to and possible relocation of the Vanessa's Corner Pub business and in general allow new development of the property. So looking at the petitioner's arguments of mistake, the staff drew the following conclusions. So going back a little bit, as some of you are aware, prior to the C1, C2, C3, I1, I2, and employment campus districts, the county had the BNR and BG zoning districts for the commercial and industrial properties. During the beginning stages of the comprehensive rezoning process, the Department of Planning eliminated the BNR and BG zoning districts, and that is how the C1, C2, et cetera zoning districts were made. So placing the properties that were originally in the BNR and BG zoning districts, the Department of Planning created a matrix to ensure that those properties would be put into the correct C1, C2, C3, I1, I2, and employment campus districts. Looking at the matrix that the Department of Planning made, if this property was not zoned agriculture, we would have placed it into the C2 zoning district due to the following reasons. The road frontage being on a major road, which is Maryland 26. The usable area of the property is less than 5 acres. The property is inside a rural village, and the surrounding area is commercial uses. Looking a little ahead in the comprehensive rezoning process, some of you are also aware that we went through the by request phase. We did receive correspondence from the applicant's attorney, but unfortunately that was after the application window had closed. So there was consideration to rezone this property back then during the by request phase. Some more staff conclusions are there are many uses permitted in the C2 zoning district that are not allowed in the ag zoning district and that are currently being used inside the neighborhood boundary. Some of these uses are automobile service center, fuel station, tavern or a bar, and a general retail of any size. Staff believe the property could have been looked at more closely during the comprehensive rezoning effort involving the commercial districts. This conclusion is drawn due to the subject property residing in a rural village, its proximity to a commercial center, as well as its proximity to a dominant intersection in this portion of the county. Therefore, planning accepts this could be interpreted as a mistake in the zoning at the time of the comprehensive rezoning. So that was the mistake argument. As we said at the beginning, they are arguing both change and mistake. So if it's okay, I'm going to go right into the change arguments unless there's any questions.
That's fine.
Okay. So going on to the change in the character of the neighborhood, the petitioner alleges a substantial change in the character of the neighborhood. The immediate surrounding area has been subdivided into residential building lots, and a commercial development is planned along Liberty Road just east of the property. A refresher, here is the neighborhood boundary, and I believe these two northern properties are the properties that the subject property was divided off. And then again is just the neighborhood boundary that they are arguing a substantial change occurred in. And then staff conclusions for their change argument is planning staff recognizes that the property was legally divided off, and though that is a change for the subject property, the petitioner has failed to prove a substantial change in the entire neighborhood boundary. Furthermore, the Maryland 26 and 27 intersection has been zoned commercially since 1965, and prior to it being zoned C2, it was zoned BG, contradicting the petitioner's argument that a substantial change has occurred. So that's it for the arguments. The staff recommendation on rezoning is planning staff recommends that the zoning for the petition be rezoned to C2 or commercial medium. The petitioner failed to prove a substantial change has occurred. Staff believes there is reasonable information constituting a mistake in the zoning during the most current comprehensive rezoning. So next steps is today we are here before you for a recommendation, favorable or unfavorable, on rezoning this property to the county commissioners. We are going to the county commissioners September 29th for an introduction and a request to go to public hearing. We have a tentative date scheduled for the public hearing of October 20th, and then we have time scheduled with them on November 3rd for discussion and a possible decision. So I realize that was a lot of information.
No, that was very helpful. Why don't we hear from Mr. Schaefer?
Thank you. We've got a tough argument on the substantial change issue, so I'm going to submit on the record there. And the reason that's a tough argument is because the facts are pretty tough for us, and the most recent comprehensive rezoning was so recent. And generally speaking, when you make a change argument, you have to make the argument that the change occurred since that most recent zoning, and furthermore, that it's not in accordance with the zone for the property. So it's really a narrow window. Mistake, however, is a very strong argument here. It is, as staff recognizes, this property and many of these properties, and this is not a criticism of anybody, when this was zoned agriculture in 2020, or land use and then zoned, nobody took a look at this piece of ground and said, what should we do with this? They looked generally at an area, and they didn't change anything in almost the whole county, including this area. Now, if they, and this is what staff recognizes in their report, if they would have looked carefully, as they are now, and by the way, Mr. Sweet purchased this property in 2020, missed by a couple weeks the window for applying for the C2 in the individual thing, and therefore it was never considered for as part of that. It wasn't considered and turned down. It just didn't get looked at. And as staff says, if it would have been, there would have been a favorable recommendation. They list the criteria that they looked at, and I think a nice job, and also point out that there's very supportive language in the master plan document for this sort of rezoning. In other words, in rural villages, encourage small neighborhood commercial development that is consistent with local character and that revitalizes historic properties. Now, I know, because I've been around here for a while, and some of you know, that this corner, and especially this particular corner, has a commercial history. I knew it as Wagner's Corner when I came to Carroll County in 1978. And I remember being quite pleased and fascinated by the fact that you could get a first-class cream of crab soup at a gas station in Carroll County, because it was a gas station, and then you filled your gas, you went in through the little area where they took your money, because in those days they actually took your money for gas, and then you walked to the right and there was a dining room, and it was a quite nice dining room. I was really surprised. I was anyway, and that business thrived, and it then, as many restaurants do, it petered out. You know, somebody that loved it and ran it, and then it was revised, and then at one point they had a Chippendale show down there, and the liquor board didn't like that. But it kind of went to a different.
Before we were there.
It went to a different kind of a Wagner's Corner operation. So Max and his significant other, Vanessa, at some point bought it, and it's evolved into what I think you know now as Vanessa's Corner Pub. Now, during that saga, septic became a big issue, as anybody, you all are now becoming more familiar with septic probably than you ever wanted to be, but you can't put a restaurant on a lot that small, and you just can't do it on a septic. If you tried to do it now, there's no way you could do it. You couldn't meet the perks. You'd have to buy another acre. Well, so the zoning authority, I think they could have known that, but there's no evidence that they did know that about these septic problems. I mean, the health department knew about it, but there's no real thing. So that is the kind of thing that in legal parlance can classify as a mistake. When you zoned a piece of property, not you personally, but when the county zoned a piece, they didn't know certain facts that were important. One of which is that this property needed more land to survive. And they also didn't know, maybe, that the land next door to it was going to get cut out. It wasn't going to be we did the work, I can't remember, a 50 or 60 acre farm. It was going to be 6 or 7 lots, one of which was going to be 7 acres, located right next to this and fronting on Liberty Road with existing driveway entrances. Because it had been historically used. Is there an old house on there now? There's still an old, probably a tear down. So that forms the sort of the basis for our mistake argument. And once you get past the mistake argument, and Heather, Hannah, I've seen you so many times recently, I can't remember the number. Hannah correctly pointed out that once that's the first step, the mistake or the change. Once you get past that, then you start looking at, does this make sense? Big deal, you showed there's a mistake. You're asking for C2. We don't like, it doesn't make sense there. Well, here it makes eminent good sense. It's in conformance with the master plan. It potentially allows and I'll tell you, it's no secret, one of the keys to this is that it would allow the redevelopment of that entire corner because it's under the control of essentially a single owner, a guy with a principal. He can, and if he did redevelop, it's possible that Vanessa's Corner Pub would be part of an adjoining, part of the adjoining piece. It's also not only possible, it's for sure that any redevelopment would have to comply with the modern codes. So the result would be a better, not pumped out septic system, and one that can meet the stormwater management regs and has enough land to do it, and it could be a real amenity. The last thing I'm going to say is that, whether you agree with me, that area desires a little more commercial development. I'm not talking about any big shopping centers or anything out there, but it's not, that's underserved by restaurants and other things. Anybody that lives there, knows that, or anybody that's been around there knows that. So we respectfully request your recommendation in accordance with the staff's recommendation to give the commissioners a favorable recommendation, and then we will look forward to presenting our case on mistake to them at a public hearing. Thank you.
Trevor, do you have anything else to add?
Oh, I'm good unless you guys have questions.
So I have a little bit of a question. The change or mistake, we throw those terms around a lot when we have these zoning requests come in, but it's more, as you have said to us many times, it's more than just simple change or just a simple mistake. And so it has to be a mistake in the existing zoning classification, really. And I'm looking at the report and the bullet points that we have. I'm just having trouble following it a little bit. So one of the number one reason that put forward to us that there is a mistake in the existing zoning classification is because the subject property is located immediately adjacent to an existing commercially zoned and commercially used restaurant, bar, Vanessa's Corner Pub. But so what? I mean, it's also adjacent to an agricultural piece of property. Doesn't that cut both ways? I mean, how does that help us? If I want to get to where you want us to go, help me help me make that connection.
Well, here's the connection. It may sound a little, but when someone chose to place the agricultural zoning designation on this 7-acre piece of ground, okay, I submit to you that when they did that, they didn't necessarily say to themselves, is this located next to an existing commercial development? Now, they, certainly if they would have focused on it, they would have been able to figure it out by looking at Google Earth or by being familiar with the Taylorsville area. If it would have been one of you or, that lived in that area, you would, but there was, and I think that's one of the things that planning says, is that this didn't get looked at that carefully. So I would ask you to assume, maybe you're not willing to assume, that nobody said, is this next to Vanessa's Corner Pub? And, to take the argument one step further, and Vanessa's Corner Pub is really too small for, it's got septic problems. Probably didn't, that's something they almost for certainly did not know, and may need to expand. So that would form the basis for a mistake argument. Mistake is a malleable kind of a concept in this thing. There have been case law that says the mistake must be basic and actual, but there's also case law that says if the zoning authority made assumptions which turned out not to be correct, maybe one of which in this case could be that this is a viable agricultural piece of land. Another assumption, which may or may not be correct by the zoning authority, would be, gee, this 7-acre piece of land, which by the way was only recently cut up into 7 acres, even though it was on record, I doubt if they even knew they were dealing with a 7-acre piece, I don't know. But someone would have had to say, if they considered it, gee, that would be a great little estate lot for somebody, wouldn't it? And I think that's part of what you do for a living, is you look at land, not for a living, but for whatever your stipend is. But it is, when you look at a piece of land, you look at the appropriateness of it, and does it move the community forward? Does it contribute to the tax base? Does it create a quality of life? Yeah, you could sell that 7-acre lot for a single family and have a residential driveway coming out onto 26, because it doesn't have any other frontage. All right? But is that the ideal, is that the appropriate zone? Now, I'm now melding over into the policy area, but when you look at that land, I think you can conclude that it was a mistake to put an agricultural zoning designation on that.
What's the zoning designation on the land on the other side from Vanessa's?
C2, I think. She should, can you put that
That's what I
zoning
meant.
map up again?
It's C2.
Yeah, that's the other thing I'll point out to you, is that in terms of like a puzzle piece, and it doesn't, obviously, it doesn't mean anything unless you consider it further, but this fits really nicely. It fits right in. We're not asking for commercial zoning in the middle of Taylorsville, somewhere else. We're coming right up against a fairly good-sized commercial area here. We're expanding that commercial area, but for good reason, so that you can support some reasonable development and the expansion and survival of an existing business in Carroll County.
Thank you for answering my question. Do you all have other questions?
Is the body shop, is it Wustlers, or is that C2?
Yeah,
And the 7-Eleven C2?
yeah.
And the liquor store, that's all C2 on that corner except for Vanessa's.
Yeah.
And there is an approved site plan for the red area that's on the southeast, down further down toward the purple line.
Right.
That's a approved site plan for a strip center, a retail strip center, and self-storage.
So Vanessa's corner is C2, but the lot next to it is not.
Correct, correct. And the
Yeah.
Vanessa's Corner lot is just the front piece of that
Yeah.
smaller piece in the, yeah.
Any other questions? So you need from us exactly what? A motion?
We're asking for a recommendation from you to the Planning Commission to approve the rezoning.
Favorable or unfavorable recommendation to the county commissioners.
So what will happen, just for clarity, is the staff report that you have now in front of you, it has a staff recommendation. Then we'll put in the planning commission recommendation, and then this will become your report that we forward to the Board of County Commissioners, that they will utilize in their process, and the first step of which is we request to go to public hearing, and then have the public hearing, and then eventual discussion decision for adopting and changing the map.
Okay.
And then if there were any changes, blow up that corner, rebuilding, all that kind of stuff, it would have to go through the normal.
Yes, so the development process would be the same. So this is just changing the rules and regulations essentially on the property from ag rules to now commercial medium, C2 rules.
So you're seeking a motion for a favorable recommendation to the Board of County Commissioners?
Correct. That is a staff recommendation.
Okay. Is there a motion to that effect?
I'll make that motion.
Okay. All right, so we have a motion for a favorable recommendation to the Board of County Commissioners. Is there a second?
Second.
Okay, so we have a motion and a second for a favorable recommendation to the Board of County Commissioners. Is there any further discussion? Can we just do a voice vote on this?
Yes.
Okay, all in favor?
Aye.
Anyone opposed? Anyone abstaining?
Thank you very much.
Recommendation. Good luck, thank you.
Thanks.
All right. Right, next item is item 19 on our agenda, which is rezoning case 227, MJY Investments. And I believe we're going to hear from Ms. Hannah Weber on this.
Yes.
Mr. Schaefer's clearing off his desk.
Good afternoon.
Okay, so as was introduced, we are here for another rezoning case. This is rezoning case 227 MJY Investments, and I'll let Mr. Schaefer do his introductions again.
Thanks. Clark Schaefer, on behalf of the applicants, which is MJY, which is Jeff and Mark Powers, and I have Marty Hackett from CLSI, who's our land use consultant on this project.
Thank you.
Jumping in, you'll remember this was also introduced to you all at your August 31st meeting. This property is approximately 10.192 acres. It is the home of the YMCA, just north of the intersection of 97 and 32. The argument for rezoning is both change and mistake again. The petitioner is requesting the zoning be changed from agriculture to C2. We are in Election District 7 and Commissioner District 3. So we have a neighborhood boundary established. This is approximately 240 acres. I'm not going to go through every institution that is in this neighborhood boundary because you guys are very familiar and there is a lot. The uses are a mix of residential, institutional, and commercial. So inside the neighborhood boundary, there is also a mix of zoning. We have R10,000 on the northern end of the neighborhood boundary. We have conservation of all of the institutions also north of the property. And then to the south, we have a C2 zoned property. This was done during the comprehensive rezoning by request phase, as I'm sure you guys are familiar with.
I remember that one well.
Okay, as with the last one, this was also sent out for agency comments. Just some things to note in this one, this was sent to the City of Westminster because this property is inside their growth area boundary. Also, we sent this to the Baltimore Metropolitan Council, specifically the Reservoir Technical Group, because this property is located in the Liberty Reservoir. And we received no agency comments for this rezoning request. So as we said at the top, there is a argument for mistake in the current zoning. The petitioner alleges mistake because the agriculture zoning designation is inappropriate for the existing recreational family center multipurpose use on the property. The zoning designation does not recognize the substantial undeveloped area on the property, and it is a mistake to apply the restrictive agricultural zoning classification given the substantial public infrastructure available in the area. And just to go along with his argument, the subject property is 10.62 acres, and approximately 6 acres are being used for the Y, which leaves a little under 4 acres of undeveloped area that's zoned agriculture. So staff concludes that the subject property could have been looked at more closely during the comprehensive rezoning effort. The subject property lies within the city of Westminster's growth area, and given that it's a growth area, you don't really see a lot of agriculturally zoned properties inside a growth area. And also the existing infrastructure of water and sewer services shows that maybe agriculture is not the best zoning district for this property. The petitioner is also alleging a substantial change in the character of the neighborhood. The neighborhood essentially consists of the institutional commercial corridor, which has substantially grown in recent years. The property immediately to the south, as we discussed, was rezoned in 2020 during the by request phase. The neighborhood has increased in use and intensity with new developments, and there has been substantial improvements to the nearby intersection of Maryland 97 and 32. Staff draws the following conclusions for the change in the character argument. Looking at the annotated code, and as was alluded to earlier, the change in the character of the neighborhood may occur where new or expanded sewer facilities are shown, where there is increased traffic flow and or rezonings have been adopted. Changes in the character of the neighborhood prior to adoption of the comprehensive rezoning, which for Carroll County is 2020, may be considered only in conjunction with subsequent changes. So planning recognizes that obviously there was a rezoning to the south of the property. However, this does not mean there has been a substantial change in the entire neighborhood boundary. Looking at the entire neighborhood boundary, there has been insufficient improvements done to the neighborhood since the last comprehensive rezoning of 2020, which would constitute a substantial change in the overall character of the neighborhood. So again, we have the staff recommendation. Planning staff recommends that the zoning for the petition area be rezoned to C2 or commercial medium. Planning staff feels that though the petitioner failed to prove a substantial change occurred in the neighborhood, there is reasonable information constituting a mistake in the zoning during the most current comprehensive rezoning. And we have the same next steps, if I can cut that part out.
Okay, very good, thank you. Mr. Schaefer?
Thank you. So this one, in my opinion, this is probably one of the most interesting areas in Carroll County in terms of zoning and planning. You've got the city boundary, which is jagged everywhere, and they're everywhere. But here, Pritz is in, Washington Heights Medical Center is out, okay? Middlebrook is in, Farm Museum's out, hospital's out, and so that whole corridor, I call it the corridor, including the Center Street corridor, which is one of the most, well, it's a heavily developed corridor, mostly institutional, but mixtures of commercial and some residential, which really, I'll probably, some people will really not like me saying this, but it probably should be part of the city of Westminster. I mean, it's urbanized, and you know why it's urbanized? Because the water and sewer system extends down there like crazy. Okay, way outside the city limits. It has for years, and Westminster did that. So what you see in that corridor, and you know, is it developed based on non-conforming uses. I mean, I think Huffman's Ice Cream is a non-conforming. Okay, the medical center, the David Green, which now it's now called the Professional Center, that is located there where A1 Auto Repair was as a replacement for a non-conforming use. That was not zoned for that. So my point is that corridor begs to be looked at, and planning, to its credit, sort of acknowledges that in its report. Now, I also, and as is pointed out, and I think there is a change argument here, although I'm not going to push it, because this one, the Youth Services Bureau is a major improvement there. It happened before 2020, yes, but does that mean you can't count it here? That's on a piece of ground that's owned by the county, or what? I think it's leased to the Youth Services Bureau. The major expansion of the VOTEC, the development and increased use of the Farm Museum for events, et cetera. And then, of course, the obvious one, at least in part, is the rezoning of the corner piece, the Kiker piece, from agriculture to C2. Now, one little, when the Y, I remember when the Y was built, and the Y was built on a private well and septic. I think it was definitely well. And then very shortly thereafter, they had water problems, and the city reluctantly extended the line down there. In any event, we agree with planning, obviously, here, that when you look at this piece of land as we have now, you see that the agricultural zoning just doesn't make sense. And I hate to be, I hate to say it's self-evident, it's a mistake, but it's almost like no one could have looked at that, thought about it, considered it in its location and said, yeah, agriculture, that's the ticket. Let's look at the uses allowed in the ag zone that you could put that piece of ground to. Well, you could farm it, yeah. Maybe Matt wants to come up there and put 4 acres of corn on it, I don't know. I doubt it, because that road's pretty heavily traveled. But it really doesn't pass the smell test in terms of zoning and agriculture. And so, now we look at some other factors, which planning has pointed out, which is it's in the growth area. It's got ready access. It's infill development, the kind of development that we want to encourage to occur there rather than squeezing out across Short Lane, into the ag area. That is really the ag. There's a lot of ag down there when you get out of that corridor, which is great. Those roads create a boundary, probably a very, very long time boundary with water and sewer not going across them. So, but if you don't allow the development to occur in your growth envelope, it's going to try to squeeze out elsewhere, and that's not good. So from a planning standpoint, this makes a lot of sense. We think there's enough evidence on mistake and or change to support it, and we would appreciate, we hope you will agree with the planning commission's or the planning staff's recommendation. Oh, by the way, one more point. Yeah. This is not a plan to get rid of the YMCA. They have a long-term lease there, yes. And yes. This is not a plan to get rid of the YMCA. This is a plan to look at the development potential of the remaining parcel there. Thank you.
The use of the YMCA on that property, is that a principal permitted use in C2? Would that?
Yeah, that's a good question.
I don't know off the top of my head.
Well, while you're doing that, just a couple quick comments. One, I do agree, this seems to be sort of a bastion of non-conforming uses that has developed over the years, and it is now what it is. I don't know how we missed it doing the comprehensive rezoning, because we focused on that little piece down at the end, and as I say, I remember that discussion very well.
That's because that was a by request. So the property came over and requested during that time frame.
Okay, but we didn't take a look at
rezoning. And just a little bit of history too, is that this particular property within the municipal growth area was governed under the county environs plan. Then the city updated their plan, which included this area in the Westminster plan. So we have a lot of conflicting, overlapping plans. And so moving forward, the hope is to get this all situated with a more cohesive plan from both the city and county together.
And that plan was 2009, the environs plan.
Okay. So I don't know what happened in 2020, but it does seem self-evident when we look at what's happening on the ground and what's developed. It isn't agriculture. It just isn't. And it seems like the zoning ought to reflect what's there. And so I very much agree that this seems to meet the standard for mistake, so.
And yes, it's allowed, it's a primary principal use in the C2 indoor recreational facilities.
Okay,
Yep.
good, thank you. Any other questions or comments?
I guess I would ask, I mean, in that, I think I read in the summary, Hannah, that you provided that Westminster has it designated in their plan as conservation. Why not conservation? Why C2? Why not conservation?
That was requested by the applicant.
The conservation was requested by
The
the?
C2 was
C2 is
requested by the
not-
applicant.
I mean, that's the other way, right? Is to say, well, what's north of it is conservation. Why was it made conservation initially? And across the street is ag, right? Everything across the street is agricultural.
Yeah.
Okay, so, again, I get why it was overlooked, because it's also got agricultural across the street. It's not, what I'm sitting here saying is, I don't think it's as blatant a mistake as you think. I'm not averse to making it commercial, but I'm also not averse to saying, you know what? Let's just make the whole corridor non-conforming and call it the non-conforming corridor. But, it might also make sense to make it conservation, if that's what Westminster also has it designated.
So
I
the
don't know, I mean,
conservation designation came about a long time ago as a kind of a de facto institutional zoning designation. And I'm gonna be honest, we are, obviously with the ag conservation districts, we're looking at changing that, to some extent and making conservation more conservation, in its approach to the rules and regulations for that zoning district.
Yeah, Mr. Lester, you still have it? It used to be that they had public conservation and conservation. And what the county did, and Linda's dealing with this, I think still, although she dealt with it a little bit during maybe a lot, but she said, no, you can't just, conservation, then you look in the code, and you don't see a public conservation in the code. You go, and you look, conservation for waterworks and forest conservation and that kind of thing. So that's how, this was an institutional corridor, and they just slapped it on there. The only other point I'll make is this: you almost never see, maybe never. Well, I'm never going to say never, but you almost never see conservation land that's served by public water and sewer. It just doesn't fit. You don't want to. You want to use your systems. If you've got water and sewer systems in place, you don't want to zone it so people can't or discouraged from using them.
And actually, to your point, with that, MDE does not allow that moving forward. Properties that are zoned conservation are not allowed in the water and sewer master plan. When we send it up to MDE, they comment on that same, can't have it in that district.
Interesting.
If I may add.
Yes, go ahead.
In this situation, you'll find it, I believe in Carroll County, on all the school properties, I believe they zone them conservation because schools and colleges are a permitted use in the conservation zone. So they're not a non-conforming use. If you read, I mean, it's in the zoning regs. Schools and colleges are allowed. So, but in this situation, if you look at that whole corridor right there, it's either owned by the Board of Ed or Carroll County. It's a college, it's a high school, it's an elementary school, it's a youth service center, it's emergency services, training facility. That whole area is it's public. This is, besides the residential, this is probably, those two properties at the corner there are the only two privately held and privately type of use in that whole corridor. And I think that sets it apart a little bit
Well,
from
there are small businesses peppered throughout there, but anyway, your point's well taken.
businesses, you're correct, but most of the some of the businesses are on the opposite side of the road.
That's correct.
The landscape yard and all that, and they're actually non-conforming
And there
use.
are 20 and R10.
That's correct.
But I know when we were looking at that piece at the bottom where 32 and 97 intersect, you know, we were doing wasn't that part of the comprehensive rezoning?
The by
process?
request portion.
By request.
Yes.
But we still take a longer-term view of the
Correct.
property and how it's likely to be used over the next many years. And the idea was, given the public water, public sewer infrastructure, that it made sense to be, to recognize that it has the commercial potential, given the investment in that infrastructure. This obviously is adjacent to that, and at least from my way of thinking, matches up with what we were thinking when we looked at that piece of property, the one just to the south of it. So anyway, I'm one person. Any other thoughts or questions? All right. Well, is anyone inclined to make a motion for a favorable recommendation to the Board of County Commissioners?
Mr. Chairman, public comment.
Oh, yes, you're right. Thank you. I always forget that. We'll have to make that a standing reminder that.
Yes. I'll hold up a
Put it
sign.
on the agenda.
Yeah, thank you. Are there any members of the public that would like to comment on this property? All right. Thank you, Counselor. All right. Now, is there anyone that would be interested in making a motion that, for a favorable recommendation to the Board of County Commissioners?
I said I'll make the motion that we give it a favorable pass to the commissioners.
All right.
Second.
So we have a motion and a second for a favorable recommendation to the Board of County Commissioners. Is there any further discussion? All in favor?
Aye.
Anyone opposed or abstaining? Very good. Thank you, gentlemen.
Thank you very much. By the way, we're gonna have an 18-foot driveway for this one.
All right, we have why don't we take a 5-minute recess so we get things set up for the last two items?
Yes.
5-minute
Now,
recess.
this is the final stretch.
Right,
I
right.
promise you.
All right, good afternoon, everyone. Now we're in the home stretch. We'll go to item 21. You hear that? 21 items, 21.
Just shoot me now.
Employment Campus Solar Text Amendment.
All right, yes, so this was a marathon today, and thank you all for your patience. We have two text amendments to discuss with you today. These were discussed at your August meeting. And we do have a text amendment portion of our website, and I'm sorry, this is really big, I can't change the layout, but we have the zoning text amendment process and lay it out on this portion of the planning website. And in this portion, we have when it was initiated, the zoning categories, the changes applied to, who initiates the text amendment, and a link to the proposed changes, and if it was referred or not to the planning commission, which it has been from the board, then we'll follow through with your recommendation and then the public hearing date, et cetera. So the first text amendment for your consideration again is the amendment to the Employment Campus District regarding solar, the allowance of freestanding ground-mounted solar. This was brought forward by the county and county staff, specifically in Public Works, pertaining, this would apply to all employment campuses, but specifically to the Beatty property. And the reason is that this is an ideal location for the underutilized portion to be used for energy conversion facilities that are ground mounted. So, as we've said before, solar energy is allowed in our employment campus district, but it had to be either roof mounted or as part of a parking lot feature. I think you all have seen those types of canopies before that go on parking lots that are the solar structure. The request here is to also allow the ground-mounted solar as a standalone entity aside from any development structures in terms of a solar field, and to have those guardrails, to have it be no more than 25 acres in size, or not to exceed 50%. And one of the changes from the last time you saw this that we worked on was to make it the total gross acreage. So not just saying 50% of the acreage, but the gross acreage, or whichever is lesser. So that way, max 25 acres would be the total allowance for the solar field.
What's the distinction between acres and gross acres?
Usable.
Usable versus the net after you take out, thank you, what the unusable portion is.
So you're changing it to say 50% of the usable?
Gross.
Of the gross, whether it's usable or not?
That's right.
Mhm.
Okay, thank you.
Or to max out at 25, no matter what.
Okay.
Yep. And that these solar energy facilities may be approved as part of a development plan. I'm sorry, that underline, that's not supposed to be there. The roof mounted were always allowed. Oh, I apologize. Roof mounted were always allowed. And then the other change would make that also from prohibited to a conditional use. So it again, we'd have to go through our one other step Board of Zoning Appeals processes. And then the final change would be to what our solar energy generating systems, which is 158.153. Specifically, this particular portion here that says solar energy conversion facilities shall be permitted in the C2 district when roof-mounted, ground-mounted systems are permitted by conditional use in the C2 and the employment campus district. So adding that here so that way it relates back to the conditional use use table. And again, putting the size limit here as well. So it's in two places in the code. The actual employment campus portion and then the actual discussion of what an energy conversion facility is. And this is just the rest of what the definitions are for solar energy. And that would be the only two portions of the code that would be amended for this text amendment portion. Scott Graff is here from the Board of Public Works, from the Department of Public Works. If he has any additional information he'd like to add regarding this proposed text amendment. Nope, he does not. Are there any questions, comments, or concerns? This is pretty straightforward text amendment for this particular district.
I think it also helps that you brought it up to us before, so we
Mhm.
got a chance to
Mhm.
noodle it through a little bit. Do you all have any questions or comments about this?
I will say that when it comes to the issue of solar, again, I'm for it, but we continually are asked to waive setbacks and those kinds of things when it comes to this kind of thing. And Linda, I'm getting off topic, and I know you want to talk about this. I want to talk about it from a 30,000-foot level. I really want to hold the line on those setbacks and things going forward. So when you as staff and when y'all review these plans and you bring them forward, I'm just going to say from here, unless there's extenuating circumstances that warrant us, reducing those setbacks and reducing buffers and all those kinds of things. Because again, as a county, I think we want to be proactive in this area, so this is good. I'm supportive of this to stay on target. But when it comes also, when we start thinking about what we want our county to look like 20, 30, 40 years from now, and how these solar farms fit into that, I do want there to be a visual buffer between these farms and roads, homes, whatever, to where, when we see our county, it hasn't turned into a solar field. And so that's just a comment, and I apologize because I'm making an editorial comment, but we've talked about it earlier today in terms of variances and mitigating circumstances, and everything's unique, and I get it. Y'all are asked to do things certainly, and I'm making a longer meeting longer by saying this, but I really want to encourage us as a group to kind of have some backbone in terms of for our county and our citizens. This is something we're trying, and let's do it right. And if we want to, erode the setbacks on down the road, well, then let's let the staff say that that's the number. But I think we ought to be pretty firm in that going forward. So
As
anyway.
we get the site plans and things that come forward, we'll
Yep.
look at each one.
That's right.
And we can take into account elevation changes.
That's
and
right.
all the other things that come up. But your point's well taken.
Every site's unique,
Yeah.
and I get that. But again, we're going to be asked, every time we've seen it, they've all asked us to modify it. And I think we ought to be holding the line a little bit stronger.
But as to this, you're in favor of it.
Yes, sir.
And what do you need from us on this? Do you need a vote on this or a recommendation?
Yes, so what we need now, so again, what we did with the actual map rezonings is the same here. We need a recommendation for you to forward to the Board of County Commissioners for their consideration to go to public hearing. And so in this case would be the text amendments as we've presented. If there are no modifications from this body, it would be as I've prepared it to forward up to the Board of County Commissioners for their consideration.
With a favorable recommendation?
Favorable or unfavorable if you want a modification to it.
So it's in our hands.
Could I
Of course, Michael.
I'm sorry to prolong it as well.
No.
Linda, you mentioned when you're doing your presentation, there was a max out at 25 acres. Is that for the ground system?
Yes, that's what our proposals for the ground mounted.
So that's a little different than when we heard Westminster Solar last month. I think part of the, in the industrial zones, there was no size limit for ground mounted systems. So that's a change.
Well, no, that is not different zoning district altogether.
Okay.
We're talking about the employment campus district
That's the
only.
difference, okay. So that's the title of the number 121.
See, when we get to these high numbers, I can understand.
This is why this is tough, Michael, I'll tell you. So, no, you okay with this in terms of employment
Yes.
campus?
Thank you.
Yes. All right, so we need a motion to forward to the Board of County Commissioners.
Correct.
With a favorable recommendation.
I move that we approve this and forward it to the commissioners with a favorable recommendation.
Second.
All right, so we have a motion and a second to that effect. Any further discussion? All in favor?
Aye.
Anyone opposed or abstaining? Very good. On to the Board of County Commissioners it goes. Commissioner Wance.
Got a whole list here today.
Good luck with that. Full employment
You're
mandate.
cleaning off your desk today.
Yes, we are.
Well,
Item
that is
20
the hope, before this board,
Get it to this.
leaves office, that
right.
we would like to get a couple of these items complete, and start and finish with this board. And so this last item would be one of those as well.
Okay, well, that's important. So let's get to 22.
72 days, but who's counting?
That's right. That's
How many
right.
minutes?
71 and a half at this point. All right, so we have, what is this, IL and C3 district text amendments?
Yeah, so I-1 and C3. Again, so this was brought forward on August 4th to do a text amendment for the industrial light I-1 and the commercial heavy C3 district. The request was brought forward by St. John Properties, and it's a very complex proposal. There's a lot of moving parts here. We went to the Board of County Commissioners first, as we always do, and then the referring body to this commission for these text amendments. We don't come before you as staff or property owners and bringing this information to you. It always goes to the commissioners first as the executive and legislative branch to forward to you all for your review and consideration. So this is, again, one of those amendments that was brought to our attention by an applicant that we follow the process. And you've seen this before, as I said at the introduction in August. So part of this is to add a definition to 158, specifically 002, to add a definition of the business industrial park. We've had business industrial parks for quite some time, but we only had one particular property develop under the business industrial park provision. So when the C1, C2, C3, I1, I2 districts were created, the business industrial park essentially went away for all districts, except where it was existing currently. Moving forward in the industrial districts, the I1 and I2, it was referred to as an industrial park moving forward, and specifically in the C3 and the C2, in the C3 district only, it was called a business park. And the idea of those was to, in the industrial portion, allow kind of a mixed use of some sort, to allow some commercial, but not let commercial take over so much that those industrial parks really are not industrial any longer. Same with the business park, that we'd allow some types of later industrial uses, but not so much so that they would become complete industrial in your commercial zoning districts. So that's why we just have this business industrial park as it currently stands. It's only allowed in the I-1 that was prior to April 1 of 2019. So at the time when we revised the code for those C1, C2, C3, et cetera districts, we did not put in the business industrial park as a definition because there was only one and there would only ever be one. But the applicant requested, just for clarity's sake, to add this. So we're coming before you now, and that is the purpose of the addition of this particular definition.
So this relates basically to the single property that's
Yes.
down, the St. John's property
Correct.
that's down off of 26 outside of Eldersburg?
Correct. They are the only one in the county under that provision. So they wanted to see a definition just along with that, even though this is already in the code, but as the definition as well. So just bringing that forward. And then just some cleanup here in these business industrial park under D. We just had it as, I believe, just business park, so making it clear business and industrial park. Same for D1. The now addition to the business industrial park is to have the allowance of self-service storage facilities. These are currently prohibited in business/industrial parks. So the amendment before you is to allow those self-storage facilities in the business industrial park.
Linda, do you mind if I jump in just real quick about that one? They're not actually prohibited in the business/industrial park. They count as a commercial use in the
Thank you.
business/industrial park, and so they're subject to an area limitation. So the proposed request is to exempt them, along with what already is exempt in the medical and dental centers, from that area limitation.
Yep, thank you for the clarification. That's
No,
exact.
thank
That
you.
is correct.
Thank you.
Again, now this also affects section 2 of that, with the exception of the uses listed in 1580791C regarding the size of any individual commercial use. That black text is all existing language. The new language requested to be added is self-storage facilities shall be regulated by the requirements of 158079, which shall prevail over any conflict or inconsistency with any other provisions required pursuant to this chapter. The requirements shall not apply to self-storage storage facilities developed within the business industrial park. And then number 5 of that has to do specifically with parking. And again, you have seen parking be an issue with these self-service storage facilities. And it rests with your body to allow a variance in the reduction of parking. We know that these sites don't require a lot of parking. And I will say that it is part of what I would like the planning department to work on as part of its next year's plan of projects is to review parking requirements across the county, across all zoning districts, because as we know, and the pandemic shed additional light on this, we're probably over parking. We plan parking for the peak of the holiday season, but not necessarily what's really needed all year long. So we overpark, and we have these seas of parking lots. So that's something we'd like to look at. But given that this is just specifically, this part of the request is just for this one particular property, feel it's appropriate to look at it for this particular use as we're in this particular section of the code at this time. But the future, we are going to be looking at it comprehensively like we've done the rest of the county code, but for parking. So this would be a reduction in the parking. And then this has to do, again, just with clarification and signage pertaining to the business industrial park. And again, C is in addition to the signage allowed, each building within the business park may have signs in accordance with 158114. Okay. Okay, so that wraps up the portion that is specifically for the business/industrial park in the I-1. And what I'd like to do is take each one of these district components at a time. Kelly, is there anything else that you and your clients would like to add regarding this specific amendment portion?
I just would like to add, thank you, Linda. Related to the signage, and this I said at our last meeting, so I'm repeating myself, but I think it bears repetition. The proposal there is a clarification proposal. It's not viewed as adding any signage that would otherwise be allowed. I think I also said this, but the way I look at it is trying to forecast how Jay Voigt is going to interpret the zoning code and or anybody sitting in his shoes, and try to make it as clear as possible so that if he's not around to say, oh yeah, this is what was intended, you can read it and know what was intended. And so that was the impetus for the business/industrial park definition, because it was actually one of our engineers was reading it and he went, that can be a little confusing where you can think that that means a business or an industrial park, not this section of the code. And we said, that's an interesting point. So a lot of that is clarification, and as Linda just summarized, exempting self-service storage from the area cap is one of the substantive changes that we see of that provision. The parking related to self-service storage and the general parking ratio. And then those are really the only two what we view as substantive changes to that section of the code. The others were really just intended more from that clarification standpoint.
And the signage piece is just making clear that there can be separate signs throughout the business industrial park.
Yes, it's attempting to marry this section with the overall signage section that lays forth the specific requirements here. And I'll also mention, and I'm sure Jay will speak up if he feels I'm misrepresenting this, but we did have an initial meeting prior to submitting for this text amendment with Mr. Voigt to kind of walk through all of these changes, to not only hear his feedback, but also make sure he agreed that this is, a good way of wording these things to allow for that interpretation. And so, because we wanted, the intent here was to have something where Mr. Voigt reads it and understands, obviously, what the intent is as well.
Sure. And it's always nice if the public can understand it as well.
That's the goal, right? Eliminate my job, make it so the public can read it. I'm right there with you.
Not suggesting that.
No.
But, all right. Thank you. All right, so you need a vote from us to
Yes.
approve the I-1.
Yes, I just want to ask Ms. Mathias. Okay, thank you. All right, and then just again, on the website, we have a comparison chart of the business/industrial park, the business park, and the industrial park. So again, as Ms. Miller had said, the substantive changes, again, have to do with those restrictions on the limitation of the 15% that self-storage would not be counted in that limitation. Again, the reduction in parking and the clarification regarding additional signs for each use. And those were the big substantive changes with this.
So you'd like a motion that we approve the text amendments as to the I-1 and forward to the Board of County Commissioners with a favorable recommendation?
With the I-1 specifically pertaining to business industrial
Business industrial.
parks, correct.
I do have a question.
Go ahead.
Linda, I was taken aback a couple months back when somebody proposed a 5-story storage facility. Is there a height restriction? And what is the height restriction in this area?
I believe it's 50 feet, Mr. Boyd?
50 feet. So you got what, 10 feet of floor, a 1-2-foot plenum? What do we got, guys? How many stories can you get in the 50 feet?
In theory, you could probably get 5 stories, but that's not what, it's not what we would be proposing if we get to that point, but yeah.
Good, okay.
But that wasn't in a business industrial park. I mean, this is only as it relates to a business.
Correct, this is only for
Yeah, I get
I-1
my.
specifically with that.
My thought process here is, do we have a hook and ladder that can hit 5 stories? I don't know the answer to that.
I
You
do.
know, you do? Do we have it?
Yes.
We got it? Okay.
Yeah, typically you look at it 10 feet per story, and most of our towers or ladder trucks are 100 foot.
Wow, I did not know that. That's good to know. Okay. I'll relax.
So, and again, this is just related really to one property that we're talking about.
Correct. These provisions are related to one specific property that meets that criteria.
Okay.
Yep.
All right. Are you satisfied?
Yes, sir.
Okay.
Thank you.
Sure.
Anytime you want to get all the way up to 100 foot and lean out over the top, let me know.
And a base jump from there.
I'm gonna pass.
All right.
Pass on making a motion.
And pass on getting
Wow.
on top of the thing.
Sorry, I'm back on making a motion.
He wants out of here. Let's do this. Matt, cue us up.
I'll let Peter do it. Yeah, you can.
I move that we approve the amendments on business industrial,
So that you're going to be forwarding,
forwarding to the commission with approval.
We're gonna have Linda articulate it, and then we can do a summary.
you're gonna be, forwarding, 158.002, the definition, of the business industrial park, as well as 158.079, specifically pertaining to, business industrial parks, to the Board of County Commissioners.
A favorable recommendation.
I move that we do that
More or less.
and approve it and move it on up to the Board of Commissioners.
Okay, do we have a second?
A second.
Okay, so we have a motion, which will incorporate by reference what Linda just articulated into our motion, and a second that does the same. Is there any further discussion? All in favor?
Aye.
Anyone opposed or abstaining? Okay. That passes.
Okay.
Now, you know what, I didn't ask if anybody from the public would like to comment on that, I missed that again. Anybody want to comment?
I don't believe we have any additional members from the public here today. All right, so the next part of this, again, now is with the I-1 industrial park section, which is the 158-156. And bear with me. Finicky, okay.
When did I?
Pardon me?
It's not in the chart, but the bulk requirements were in the middle there. I wasn't sure if you were gonna present those before the,
I'll come back to that
Okay,
one. Yep.
okay.
Yeah, I do, okay, yeah, I'll go to this really quickly. I apologize
No,
about
I think
that.
that they are in the chart. I'm sorry, just, it's, you know.
Okay, well then I'll go back to that. I apologize. I was kind of like following, I skipped a page ahead. The next has to do with 158-084 commercial and industrial districts bulk requirements. And this is regarding where there's a 0 yard is proposed setback buffers and landscape screening requirement shall not be applicable. And that's 158-084, item 6. And also, under B, bulk requirements within the industrial, so one was in the commercial, the A, B is in the industrial, and the same request is there, where D, where a 0 yard is proposed, setback buffers or landscape screening requirements shall not be applicable. Ms. Miller, did you want to add anything to that as well?
We do have a visual, if it would be helpful, of the existing Liberty Exchange. This is really talking about those interior lot lines of these sorts of parks, which are often, and I'm sure Tom Pilon can speak more specifically to this, but often subdivided for purposes of financing. And so there are, even though you wouldn't really see it on the ground, there are property lines in between. And so on those interior lot lines, as a result of the most recent comprehensive text amendment, we figured out how to word it to accommodate that, but what we didn't foresee is that there would still be potentially, depending on who's interpreting it, landscaping and requirements as if that were still a true property line. So I brought, or really Matt brought, several copies of the Liberty Exchange plan so you can see. And this would basically just eliminate any sort of discrepancy that one could, you know, see if they were trying to interpret landscaping regulations to those interior 0 lot lines.
So you're primarily talking about shared truck courts? Is that what we're talking about?
In some cases, yes, there are shared truck courts. In some cases, it bisects parking. You can see how some of these property lines you wouldn't necessarily notice if you were not looking at this plan.
This makes sense to me.
So does this, is there language in here that says and stipulates that these setbacks, provided that the setbacks in question are interior to the property? Are we confident that that the way we've worded this, it captures that notion?
Can you clear the first sentence that's already in there? Yes.
Both sides of an interior lot line, I got it, okay. I got it.
At least I hope so, because that
You
was,
got it.
that was the initial discussion back during the comprehensive text amendment.
You got it, all right.
So here's the question. As I read 6, it says when a 0 yard is proposed, setbacks, buffers, and or landscaping screening requirements shall not be applicable. We look down here at pad A or pad B or pad C. If we want to have some landscaping put in around those, does this mean that we can't?
For purpose of an interior lot line? If it's an interior lot line, the answer is it wouldn't, those requirements wouldn't
Inherently apply. I would say that there's never any, I mean, my statement would be there's never anything stopping this commission during a concept review phase to say, here's what we'd like to see, here are design comments. But yes, this text amendment would say that on those interior lot lines where it's proposed to be 0, which is perhaps not always the case, but sometimes it is, that then you would also not have to accommodate for the typical landscape buffer requirements.
So if we said we would like to see some additional landscape there. They wouldn't have to do that theoretically.
It would be, yes, it would be subject to whatever the ordinary landscape requirements were, if there were any, in a zero lot line situation. So, at this point in time, there would probably be no, I don't know, I
can-
can't speak off the top of my head.
If I
there's-
can,
Yes, please.
this came to our attention when, actually, our engineer/landscape architect was looking at the various sections of the code. And when the comprehensive rewrite of the commercial industrial zone was taking place, there was a pretty extensive conversation about these zero lot lines. And when you read the language there, it says the yards on both sides can be zero. Means there is no, you could have two buildings butting up against each other. So there's an inherent conflict with the requirements of the landscape manual and things like that. So where you've got these things running through the truck courts, the parking areas and things like that, it doesn't, it's just a conflict, and this is clarifying that under that scenario, you wouldn't be required to do the landscaping and the buffers because you don't have any yard to do it in.
Right.
So-
That makes sense to me. It's
Yeah,
the.
that does.
But if we look down here at pick pad C. And right now, I think there's nothing on pad C, right? That hasn't been.
Undeveloped.
Is there, would this be a zero, does this fall under a zero yard proposal?
Would it just be right here?
The answer is it could.
And if it does, then the setbacks, buffers, and landscape requirements shall not be applicable. So we can say we want all kinds of landscaping.
Right.
And you can point to the code and say, I don't think so.
On the interior lot line. So it would be interior to the park itself, not the very bolded black line here, which is the exterior line of all of the
Right.
property that St. John has developed as Liberty Exchange.
Right, but anything within the big, thick black lines, which would be pad A or pad B or pad C, if you're bringing us a site plan and we say we'd like to see some landscaping around this, this would seem to say that you can say, we're not gonna put any landscaping around those buildings.
To the interior, the way this is drafted, yes, that would be. It's not what we're trying to intend. We're trying
I
to get it to set up so that we can do what we've typically done with these.
Totally
Yeah.
understand that. I just want to, we always worry about unintended
I understand.
consequences is the problem.
So if we said requirements may not be applicable, is that softens it a bit, and we all get what you're trying to do, and I understand, how you structure these partnerships, and each building might be in its own unique ownership structure. I get the reason you want to do this. At the same time, from a approval standpoint, if we were to strike shall and insert may, does that get us to where you want to be?
I guess my concern would be is that it could, it's the right question to be asking, I think.
Okay.
My concern is that it could swing the other way where someone says, well, we want to impose in the middle of that. I know it would be totally unreasonable, but in the middle of that truck court, we think there should be a landscape buffer or something like that. So I think the question is, how do you get there?
Yep.
But just for clarity, you still have landscape requirements to fulfill. Like, so this would not, be blanketed that they didn't have to meet certain landscape requirements. The overall plan would have to. All we're saying is interior to each other. We don't have to put, anything there necessarily. Does
You know
that make
what?
sense?
I think the language is actually in the code now that I reread it. The part that's in black says an interior lot line may be zero. There's your may language. So as the planning commission, I would think under and as the planning staff and such, as they're reviewing things, they could say, well, that's not appropriate for a zero lot line. Therefore, the landscape manual would apply. But where we're approving it with a zero lot line, it won't apply. And that would actually resolve, I think, the question that you're asking.
It is.
Okay.
Me.
I'll pay myself later for that one.
Yeah.
Good, thank you.
Thank you.
Okay. Janice has to run, so.
Yes. Sorry.
That's okay, thank you.
Thank you, Ms. Kirkner. We will see
Had a
you.
long day.
So do we want to take a vote before she leaves really quickly, or are you?
Okay,
prepared
on
to-
approving, okay, can you articulate the motion?
Yes, so the motion would be 158-084, commercial industrial districts, bulk requirements to allow, where there's a 0 yard proposed, 0 setbacks and buffers and landscaping required shall not be applicable.
Okay, I will make that motion.
For
Forward
forwarding.
it with a favorable recommendation.
Okay, so we have a motion and a second, any discussion? All in favor?
Aye.
Opposed, abstaining? Unanimous.
Forgot to ask the public.
No public's come in since last time, but you're
Well, Jim
right.
said he was going to remind you, but he forgot.
Beat me
so.
to it.
Did someone abstain?
No one abstained.
Okay, I thought I heard abstain.
It's unanimous.
Okay, all right, perfect.
I'll take all the help I can get, so.
Thank you. All right, coming down, now the real final stretch. The next is specifically to the industrial park itself, which is found in the I-1 district, 158-156. The first request is to expand the retail square footage. It is currently set at 10,000 feet, and that is to move it from 10,000 feet to 25,000 square feet in size. And then to, under section 3,
Wait, can you go back there 1 second? So it says retail store greater. Do we mean greater than?
Yes, I think there
okay, I
was
think
just a,
we dumped a word, yeah.
Okay.
yeah.
Thank you.
That's an existing typo in the code.
No, I don't think so.
So, okay, thank you. So we'll make sure we add that as we forward it to the commissioners, greater than 25 will not be permitted. The following principal uses are also permitted by right with, in the industrial park without being subject to the percent limitations above. So again, almost like with the self-storage that you have with the 15%, the same request is being made for medical and dental centers within the industrial park. So to allow those to be included, but not go against the 20% limitation for these types of uses, the not industrial uses within the industrial park.
And Linda, again, there are no other places this applies, so unintended consequences wise, we're not adversely impacting or this is,
We don't know yet. We've never developed an industrial park.
okay.
So this is based under the new code under I-1, and we haven't had any development projects come forward yet with this industrial park provision. But they could, so yes, so.
Okay. Well, wouldn't you allow that?
Right.
I don't understand why we wouldn't.
Right.
Okay. I'm sorry.
That's
Move on.
okay.
Agreed.
And then the next is number 5, multiple non-industrial accessory uses may be permitted, provided that no accessory uses shall exceed 5,000 square feet, except a daycare center or health club, which may be up to 6,000 square feet, and provided that in aggregate, the non-industrial accessory uses do not exceed 10% of the acreage of the entire industrial park. To the extent that this section conflicts with the section of 158.083B2, the provision of this section shall prevail. Ms. Miller, do you want to clarify the intent with this particular?
Yes, yes, absolutely. Sorry, I only laugh because it is like the code sections, if you don't do this and look at this every day, it gets very confusing. This is again just intended as a clarification. That section that it's referencing is the, after the use chart in the code, there is an accessory use section of the code that is related to the industrial and commercial districts. And we just wanted to clarify that to the extent that there's anything that conflicts with the accessory use allowance in this paragraph, that this would be what would control in an industrial park development. We didn't see anything that we thought immediately, but it just seemed like because it was in two sections, it warranted saying that if you're developing as an industrial park in I-1, this is what applies to you.
So you're just setting a priority. If there is a conflict.
Right.
We know this isn't gonna govern.
Right.
And that has nothing to do with the section about medical and dental centers and that sort of thing, right?
No, if you want me to jump back, the medical and dental centers, again, similar to the self-service storage in the business/industrial park, medical and dental centers are already allowed in industrial parks. This proposal would be to exempt them from the area limitation
They're
that
not
they're
accessory
subject to.
uses.
Correct.
Which is
No.
what five
Correct.
or
Yes.
five deals with.
Yes.
Okay,
Yes.
thank you.
And then the next one has to do with the subdivision of the industrial park. When we originally developed this, there was no additional subdivision, or there was a cap, I guess I should say, acreage limit on the subdivision provision. And the request is to remove that it shall be permitted to be subdivided at the option of the developer. And a lot of this has to do with financing of particular parks, so to speak, and that they can, kind of break it up under different
And not have to come back to
ownerships.
us every time they want to do that.
Pardon me?
And not have to come back to us every time they want to do
Right,
that.
exactly. So that's what that provision has to deal with. And then the other provision, again, we addressed this with the self-storage in the business industrial park. And again, this is something that planning's intent is to revise all of the parking requirements in the future, and to see what some of the best practices are. Again, this would now pertain to beyond, again, the business industrial park, and would go to all industrial parks. And then the same request is being asked in the commercial flipped version, the business park, for both of these, where subdivide and to change the parking requirements for self-storage.
So we're getting started on limiting parking spaces now.
Yes, if you'd like. There's nothing developed under these models now, or, if this is something we want to wait when we look comprehensively at parking, I'm just, offering that to you as well.
Can I interject something here?
Yes, please.
This establishes a parking requirement for industrial parks. It doesn't, maybe I misunderstood what Linda was saying, but it doesn't have anything to do with self-storage. This just
Oh, I'm sorry,
establishes.
you're correct. No, you're
Yeah,
not
a
mis-
parking
I
ratio
apologize.
for an industrial park, which doesn't currently exist in the code. We're getting ready to develop an industrial park, so we need to know what our parking ratio is.
Right.
So we're proposing.
And your view is this is workable?
We believe that that's, based on 50 years, that's our sense that that's a good number.
Yeah, 50
And
years is
To
good.
jump even further than what Tom just said, in looking at that, St. John looked at the maximum commercial allowance in an industrial park to ensure that there would be enough parking. Obviously, I think it goes without saying that anybody who's developing one of these parks wants to make sure that their tenants are happy and have enough parking, but that was factored in because this industrial park provision allows for a certain retail component, and so that was taken into account in proposing that parking number. Right now, if you look at the parking tabulation chart in the code, there's no use for business park. So it leaves a question, industrial park, there's no, or business park, it applies to both. There's no use on that chart that says, here's your parking ratio. So if you're a developer who's trying to submit a plan for one of these parks, you're kind of in a catch-22 because you probably haven't leased space yet, right? You're just starting the development process. You're trying to anticipate potential tenants and then provide a parking according to uses that are on the chart. And so that's why this is being proposed, to provide some certainty. If you look at which you just did, the business/industrial park, the parking ratio is included right there in that section of the code. So we felt like it was appropriate to have it right in this section of the code. That way, again, reader ease. If somebody's looking at developing an industrial park, they look right here and they see all of the requirements that they're subject to. So that's where that came from. And I'm going to jump real quick back to the subdivision, because Mr. Weathers, we took your comments from the initial meeting on this. And in the chart that Linda has there is the language that we thought would address your one concern about subdivision. And tell us if it doesn't. But basically, we clarified with language there that any subdivision would still be required to go through the subdivision process as required in Chapter 155 of the code. So this section would not exempt you from all of the other requirements that anyone else subdividing would have to go through. It just allows for a park to decide that they want to subdivide. Again, because there's that acreage limitation, and currently it says no subdivision if you're under a certain amount of acreage. So this would allow subdivision.
That's not in this.
No, it's not in.
No, it's not
It's
in
not
that.
in the
It's in-
text, but it is in the chart. It's that blue
It
text.
says blue indicates clarifying change proposed since the initial
Right.
transmittal, so they had not received that as part of their package.
So that's the proposed text that we thought would clarify that and just make it, assure everyone that we're not exempting ourselves from the subdivision requirements of the code. We're just allowing for subdivision of these parks if they want to.
No, I appreciate that. Thank you.
Thank you.
That
And
addresses that.
going back to the parking that we just talked about, and having the table and things like that, goes back to the London Town case that you just heard, where they said, okay, here's how we came up with our parking. Well, we kind of took this amount of use and this amount of use, we kind of tabulated it, this way. This tries to alleviate the need for that. And so, yes, so when you talk about an industrial park coming through, that now would be, I guess, the first one, because the zoning administrator reviewed and said that that would meet the definition of an industrial park. So we do have one.
All right. Is there more to go through, or did you want to
No,
pause it?
no.
Well, not for this section, no.
We still have the commercial.
Yes, correct. And not unless anyone has any questions.
And so do you need a motion to approve these last texts, or are they swept up in what we already approved?
So we can do this for the 158, 156 is the industrial park, to make these changes as well.
So if you want to articulate. the
Okay.
motion Needed.
158, 156, for the allowance of retail stores,
Amendments as proposed.
yeah, amendment, okay, that's better, what Jim just said, to have the amendments for 158, 156 as proposed in the text provided.
Forwarded to the Board of County
Yep.
Commissioners
With
with a
approval.
favorable recommendation.
Yes.
Okay. Would somebody like to incorporate that into a motion?
I'll make that motion.
Okay. Is there a second?
Second.
Okay, so we're incorporating by reference the information that was just articulated about
Yes.
158, 156,
Yes.
and being forwarded to the Board of County Commissioners with a favorable recommendation. We have a motion, we have a second. Is there any further discussion? Are there any members of the public? No. Okay. All in favor?
Aye.
Anyone opposed or abstaining? No. Okay, it's unanimous.
Okay.
Thank you.
And then the next has to do with the C3 district, and that is the business park provision. And again, same as what we just talked about with the industrial park, for the, being permitted to subdivide at the option of the developer with that same provision, subject to all applicable requirements of Chapter 155 related to the subdivision. That's all I had, Kelly. Were there other, I think those were all the changes.
Yes, we did submit the letter on parking as well. I know you just mentioned it, but I
Yeah.
wasn't sure.
If you want to bring that forward, we did not submit that to them because, we can have that discussion now with them.
So, in keeping with the conversation we just had about the parking ratio for industrial parks, we also thought it would be appropriate to have a parking ratio for business parks. So we mirrored that language that you just saw for industrial parks, but with a different ratio because business parks are much more commercial versus industrial and therefore have a higher parking requirement. Was it 3.5? I believe it's 3.5 per
not written
thousand
in
square feet versus the 2.3 would be our suggestion there. Okay. I think I do. I was just gonna dig it out of my paper file. Might take me a minute, so I'll
Take
get
your
the
time.
specific number. But that was, again, and I appreciate Linda's explanation of London Town, because as you all know, I worked on that one too, and that was quite an analysis of existing tenants. So this is, again, done to alleviate the uncertainties there, provides a developer with some idea of what they're going in for, and also, hopefully, provides staff with an idea of what is the actual requirement versus going through this slightly more complex analysis as well. And I'll throw this out there too. If you're doing an analysis based on tenants, as you can imagine, that can get a little bit finicky, because if you have tenants that change, it's kind of like this constant analysis that is required between any developer and the zoning administrator going, okay, are we still in parking compliance with this tenant? And from an economic development standpoint, I would say that that's probably not exactly where the county wants to be, and having to go through that kind of analysis on a tenant by tenant situation. So I think I would submit to you that providing, a concrete ratio could eliminate those sorts of concerns going forward. Sorry, let me pull the specific. I should have had it right in front of me.
And like everything else, we can live out of this for a while and adjust if it turns out that this ratio needs to be adjusted.
Yes.
Right, and
And
then
it-
again, as I said, as we move forward, we want to evaluate all parking requirements across the county, across all districts. So this would be reevaluated, and we could have more robust discussion at that time. But this serves the needs of developments under the I-1 industrial park and the C3 business park, which we did not have.
And it is 3.5, I did confirm.
Per
Thank you.
1,000 square
Per
feet.
1,000 square feet, yes.
Okay.
That's my fault. And I apologize. I thought I had it prepared to pull up, but I don't. I apologize.
It's
But
okay.
I knew it was similar in.
We can deal with it on the fly.
I appreciate Linda, she said it verbally.
All right. Is that everything?
That is all. Is there anything else, Tad? I think that's it. We covered everything. It's a lot.
Yes.
And we appreciate it. Appreciate you going through this very deliberately with us.
So we need to make a motion on the last part
Yes.
for C3, right?
Yes.
So if you can help articulate what that motion is, either Jim or Linda.
I have it as written.
Amendments as proposed to the
Yeah,
158.
158, 159, as with the addition of the.
Yeah, with the addition of the
ratio
parking.
Business park.
So,
158 what?
158, one.
158, 159 is the
Okay.
business park
Yeah.
provision.
So the
yeah.
amendments as proposed to chapter 158, 159.
The parking's not on that one, Jim, because that's a copy
Oh.
of what was in there.
Right. Along with, and what was the parking?
Parking's 3.5 per 1,000 square feet.
Along with parking ratio of 3.5 spots per 1,000 square feet. And that would be the motion. To approve it for a favorable forwarding to the Board of County Commissioners.
So Jim, just to be clear, it'd be 158, 159, that last provision would be G, would be the parking
It
requirement.
would get
Okay.
added, tacked onto it.
Mhm.
Go ahead.
Well, that would be an amendment proposed to 158, 159.
Yes.
Right.
Mhm.
All right. So would someone like to incorporate that into a motion? You can incorporate it by reference.
I'll make that motion.
Okay.
Whatever they just said.
Okay. So we have a motion. Is there a second? Okay, we have a motion, second. Is there further discussion? All in favor?
Aye.
Anyone opposed? Anyone abstain? Passed unanimously.
Okay, and just to clarify, this will all be re-typed up, posted on our website under the zoning text amendments. All of the text that you've made suggestions today will be forwarded to the Board of County Commissioners and posted for the public hearing. This will all be written out.
And it'll be before this Board of County Commissioners.
Yes, so since you were able to get through this today, we were, weren't sure the trajectory, so this will move along with the solar on the employment campus then. So our intent is to get this before the board, before they leave office, this particular.
You're gonna have a busy
board.
71 and a half days.
Yes, we do. Yes, we do. So thank you all for your patience and working with us and going through this in detail.
And thank you for preparing the chart. I know Mary was helpful
Mary
too,
did
because
it.
that chart was.
Thank you, Mary.
Yeah, when I saw that, I said, this is a great breakdown. So I appreciated that.
Yeah, well, thank you all for putting all this together.
Thank you.
Thank you.
All right, so that concludes this item, I take it? Then we'll move on to item 23, which is general public comment, which I think we've demonstrated there is none. We'll move on to item
Sit down.
24, which would be adjournment. Is there a motion that we adjourn?
I'll move, we adjourn.
Is there a second?
Second.
All in favor?
Aye.
We are adjourned. Thank
See
you
you
all
on
very
the
much.
5th.
Thank you.
Well